Item number 37, WPC 5620 of 2024.
Petition allowed.
Marshal, please.
Made pledge as a loss in my lord. My lord, since CRP has been filed on my lord 18/6, my lord. I am praying for listing on Monday, my lord.
Monday.
Obligement.
May it please your lordship. Lordship, item number 22, lordship. In case senior counsel is out of station, lordship. Can the matter be passed over for the day, lordship?
On the pair being made by Ms. M. Neriola, learned counsel for the applicant, appellant. You will inform the other side.
Yes, lordship, I have informed the other
Counsel
side.
From the other side.
Lordship, can it be on,
Matter stands adjourned for the day.
lordship, can it be on 27/6, lordship? Friday.
Before, is there any urgency?
Yes, regarding with this, with regard to the delay condonation, lordship. So, 27.
After vacation,
Okay, we'll try.
27.
Okay.
Yes,
May it please your lordship. Lordship, I beg to mention a listing of MSc appeals. There is an urgency.
why?
Execution has been initiated, lordship. Any day on the next week, lordship. Monday.
Not Monday.
Under which column?
Uh-huh.
Under which column? Which category?
Orders.
Wednesday, 25.
Obliged.
May I please, your lordship, I beg to mention one RSA for listing in orders column, your lordship.
When?
Next week, if possible, your lordship.
Is there any urgency?
Lordship, it is a 2018 matter and it's been pending since long.
Yes.
lordship.
May I please, Lordship,
14th
Lordship,
July.
Lordship, I beg to mention item number 35 on behalf of Mr. S. Samaria, Lordship. Also, leading counsel, Mr. Samaria is not well today, Lordship. Can it be passed over for the day, Lordship?
How many adjournment you have
It is
taken?
fast, Lordship.
Fast.
Fast.
What is your name?
MM Zaman, Lordship.
Mr. M. Zaman, learned counsel for the petitioner with consent from the other side, price for list. You inform the other side.
No, Lordship, because we try to call him, Lordship. His
No.
phone number is not in operation,
We will call the matter.
Lordship.
Yes.
May I please your lordship, I would like to mention item number 21. The matter may be adjourned for today. Counsel suffering from ill health. So the matter may be fixed on Monday
You
or
are appearing for?
P. Mishra, respondent, on behalf of P. Mishra.
Your good name?
S. Das.
S.
Das.
Ms. S. Das, learned counsel appearing on behalf of Ms. P. Mishra, learned counsel for the respondent with concern from the other side. You inform the other side.
Yes,
With
I was
consent from
informed.
the other side, as for listing the matter, when?
Monday.
Hmm.
On
After vacation.
After the-
Monday or Tuesday.
No.
Lordship, petitioner, other side was told me that matter may be fixed on Monday or Tuesday. It is urgency, Lordship.
Tuesday,
You say-
22nd June. Tuesday.
Tuesday.
May it please, my lord, I beg to mention for listing an IN application on the next week.
Take
Uh,
that from him.
24th June.
Next week, my lord, because there is urgency as it is for restoration of RFA number, which was dismissed for default. And if it is
No,
enlisted.
that's all right.
26th
Take it
June.
from him.
26 June. Much of. Please, your lordship, one RSA matter for on prayer for listing for hearing. It's a 2016
Hearing
matter.
after vacation.
After vacation.
After, before vacation, it
No.
can be.
not possible.
May it please your lordship, with regard to item number four,
You take
lordship,
it that from him.
29 July, 29 July.
with regard to item number four, lordship, I have filed an amended petition. That has not come in the record. Lordship, I kindly call for it, lordship.
For motion, item 1,
May it please your lordship. My lord, this transfer petition has been filed by the wife for transferring a titleship matrimonial 58 of 25, my lord. The plaintiff is at annexure 9, page 33. Kindly come to annexure 9, page 33, my lord.
Okay,
Relevant is at paragraph 4, my lord, page 36.
but where the parties are hailing from?
My lord, the wife is from Namru, the husband is from Jorhat, and in the entire claim, no whisper has been made, my lord, that they resided in Guwahati since marriage of 2013, my lord. And the exhibits speak for itself, my lord. Kindly come to annexure 2.
Okay. Heard Mr. J. Boyce, learned counsel for the petitioner. In this petition under under section 24, read with article 2227 of the Constitution of India, the petitioner has filed for transferring TSM case number 58 of 2025
My lord.
under section 13(1)(a), 13(1)(b) of Hindu Marriage Act pending before the Court of Learned District Judge Jorhat to the Court of Learned Principal Judge Family Court at Guwahati. Family Court at Guwahati. Mr. Boyce, learned counsel for the petitioner, submits that the respondent herein has instituted the titles of number so and so before the Court of Learned District Judge at Jorhat. But after the marriage, the petitioners were residing at Guwahati. And suppressing the aforementioned fact, the respondent herein has instituted the suit before the Court of Learned District Judge at Jorhat. And as such, Mr. Osha submits that the title suit number so and so pending before the Court of District Judge Jorhat may be transferred to the Court of Principal Judge Family Court at Guwahati. The submission of Mr. Osha needs further consideration. At this stage, notice be issued to the respondent, returnable in 4 weeks, that be taken by registration post with AD and also the usual process within a week from today. Till returnable date, the proceeding of PS number so and so pending before the Court of Learned District Judge Jorhat stands stated. List after 4 weeks.
item 2,
May it please your lordship. My lord, here in this case, my lord, the the respondent, my lord, filed a money suit against Nazrul Islam Lashkar. Who-
Okay.
Against Nazrul Islam Lashkar. Then
Your pair was okay.
Nazrul Islam Lashkar was my father, my lord. Suit was filed, date is important, suit was filed in 2012, my lord. And he died on 12/7/2012.
Okay.
He died on 12/7/2012. Thereafter, the substitution application has been filed by the respondent, impleading Swapna Begum Lashkar as the legal heir. Suit was decreed against only Swapna Begum Lashkar. Now, thereafter, the execution filed Executing court decided yes, Swapna Begum Lashkar is liable. Then now what happened? An application has been filed for adding this present applicant as the legal heir, as legal heir of the in the execution proceeding. Though it was abated on 12/12/2012. Impugn order at page 53. Page 53. The second paragraph, the learned advocate for the decree holder submitted that decree holder as a plaintiff did not have knowledge that defendant Nazrul Islam Lashkar had legal heirs other than his wife. And as such, he had impleaded only his wife as defendant on the death of original defendant. And substituted defendant number Swapna Begum Lashkar did not inform the court or state in the written statement. Now, the suit was abated against the present petitioner. So now how can this executing court can implead us as a judgment debtor? Now the executing
But
court,
Mr. Ghosh,
yes,
it is not in dispute that you are the legal heirs
yes,
of the original
Yes.
defendant.
yes, it is not dispute.
Hmm.
Kindly see order 22 rule 6.
Hmm.
Abatement take place if before, kindly see order 2, no abatement by reason of death after hearing.
No, whether they have been impleaded before pronouncement of the, sorry, during the course of trial,
They
they have
have
not been made party.
not made party. During course of the trial, they have not made
So
party. Only wife.
how the question of abatement come?
Yes, abatement, it was abated on that day itself, after death, when in the suit, they have not impleaded.
You are
Abated in 12/12/2012.
order
Order 22 rule 6, kindly see. The question, answer to your question, my lord, when abatement took place or when abatement did not took place. No abatement by reason of death after hearing. Lordship got it? Notwithstanding anything contained in the following rules, where the cause of action survive or not, there shall be no abatement by reason of death of either party between the conclusion of the hearing and pronouncement of the judgment. And here in this case, after filing, during trial, the abatement suit was abated against the present petitioner. Paragraph 2, kindly see, my lord, when they have died, when they have impleaded. Paragraph 2
paragraph 2 what?
of my petition, my lord. 1 and 2.
Whether all the legal heirs of the defendant were impleaded at the point.
No, not impleaded.
If not impleaded, then whether the question of abatement would come.
Yes.
Hmm?
Not impleaded means it was abated. But not made party, they have filed application only against wife only, not against other legal heirs. In the decree as well as in the judgment also it reflects. Kindly see page 11, judgment. Substituted. Page 11. Swapna Begum Lashkar was substituted.
Yes, that is the admitted position.
And it was,
Only the wife was substituted.
yes. Now,
The other legal heirs were not substituted.
that means,
Not been informed. No, it was also not informed to the court.
my lord, that is why they have filed application for substitution.
How many defendants were, how many legal heirs of the defendants was there?
That question has not been decided by the trial court also, because after substitution, The judgment was passed, then decree was executed against Swapna Begum Lashkar. Decree was executed against Swapna Begum Lashkar also,
Only her part,
my lord.
only her part was executed.
It was after filing of the application by Swapna Begum Lashkar, but decree was executed against her. Now, after my question is that after abatement, whether executing court can go beyond the decree. There is a provision for setting aside abatement. All these things would have been taken place during trial.
No, you first.
Once it is
notice court
abated-
that without there being implemented, the suit stands abated against them.
Yes,
Is it the proposition of
yes,
law?
it is the proposition of.
Show me any other provision. Any other
Once
citation,
it is not
there is any
substituted,
citation
my
on
lord,
that
during trial, once it was not substituted, within a specific time period, kindly see the order 22 rule abatement regarding when it was abated, my lord. Order 22. Procedure in case of death of one or several defendant,
Order?
or 4, order 22 rule 4.
Hmm.
Where one of two or more defendant dies, lordship got it? The right to sue does not survive against the surviving defendant or defendants alone, or a sole defendant or sole surviving defendant dies, and the right to sue survives the court. On application made in that behalf shall cause the legal representative of the deceased defendant to be made a party and shall proceed within the suit. Any person so made party may make a defense appropriate so and so. Then C 3, where within the time limit by law, no application is made under sub-rule 1, the suit shall abate against the deceased defendant. The court, whenever it think fit, may exempt the plaintiff from necessary for substituting legal representative and such defendant who has failed to file written statements. This part is not. My question is against the legal heirs who has not made party, against them suit was abated.
And learned executing court had also observed that the settled principle of Mohammedan law is that each heir is liable for the death of the deceased to the extent only of his share on the death proportionate to his share of estate. This is the observation made by the learned executing court.
My lord, whether executing court can enter into all this merit of this case. Executing court only will execute the decree, nothing else, my lord. And when the decree, earlier, that part, 1/7 or 1/8 part, which has been decided again in favor of the wife, that order has not been challenged by them. There may be some illegal order or whatever it be. That order they have not challenged. I have annexed that order also. Now question is whether against this against the present petitioner. I am not exposing the against in favor of wife or anything, my lord. I am only against the present petitioner. When
That's all right. Is observation made by the learned executing court. You see, admittedly, you are the legal heir of the principal defendant.
My lord, even if I am the decree which was passed, the suit was not filed against my my mother or against me. Suit was filed against the dead person, my lord, when he was alive. When he was alive. At that point of time, suit was filed.
You explained this, how the executing court is wrong?
Executing court has no jurisdiction to entertain into this case because,
This observation.
yes, this observation, my lord.
You-
It is a wrong finding,
you
my lord.
prepared with
Wrong
this submission on
assumption.
Monday.
Whether executing court can go beyond the decree, my lord.
Yes, there is a provision in the CPC. You go through it and you come prepared on Monday. Heard Mr. SK Ghosh, learned counsel for the petition.
Not Monday, my lord.
When?
Then it may be taken up after vacation, my lord.
Okay, no problem. This is the matter after vacation for further hearing.
Master.
Matter number 3,
None appears for the petitioner on call. It appears from the record that on 19/5/2025 also the petitioner remained absent. Accordingly, taking note of the order dated 19/5/2025, this petition is not dismissed for non-prosecution.
item 4,
May it please your lordship. Lordship, in this case, there were some errors. And I have corrected all the errors and I have filed this amended petition, lordship.
Mr. Gogoi, have you received a copy of this?
Lordship,
You,
yesterday I have received a copy.
yesterday, you have gone through same.
No, yet to be, I don't have control.
No, it is almost the same, only the dates have changed. Not even the dates, only that.
Use correction, lordship, in IA, which was filed in earlier, lordship, and paragraph 4(6)(f), 4(6)(b), 6(c), 6(d), 6(e), 6(f), 6(g).
And
Lots of correction is there, better than
Then lordship, respondent number 2 is a pro forma defendant, lordship, and I have no claim against him, lordship.
lordship, that is correct, lordship.
And they have not contested the suit also. It is only because in the suit they are a party, I have made them a party, lordship.
Lordship, yes, lordship. I'm performing it.
Admittedly, lordship, I have taken more than 8 adjournments, lordship. Only I'm praying for, lordship, just one chance to present my case, lordship.
Why the review petition was dismissed?
Lordship, the review petition order is at page number 36. The reason is that, lordship, I have taken more than one adjournment. And the reason which I have cited is not covered under review. That is the reason.
Where is the impugned order?
Lordship, it is at page number 36. I have impugned the initial order and the review order both, lordship. Review order, lordship, would find at page number 36. According to the learned court below, this particular fact does not come under error apparent in the face of the record for review.
So where is the past impugned order?
That lordship would find in page number 27. Since the petition 394 filed on behalf of the defendant praying for another date for DW showing cause that senior engaged counsel for defendant have gone outside due to his personal inconvenience and defendants are unable to communicate with him. Heard the learned counsel and perused the CR which reveals that the defendant has already taken over all adjournments for DWs. It is also appears that defendants were specifically directed to produce DWs today, but the same is not done. Moreover, grounds shown in the defendants are found to be not satisfactory to further adjourn the case. Hence, the petition is rejected and DW is closed.
Whether any DW was examined earlier?
Yes, Lordship. One.
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 So you pay some amount of
Yes,
cost.
Lordship. Yes. Lordship, a cost was already there, Lordship. Once.
Pardon?
One time cost was already imposed, Lordship.
Oh, no.
No, this in this lower court, Lordship, defendant shall earlier deposit the earlier cost on the next date fix. So there was one cost already there. I'm ready to pay another cost, Lord.
For Mr. P. Decker, learned counsel for the petitioner, and Mr. Gogoi, learned junior government advocate for the respondent number,
Two, Lordship, two,
respondent number 2.
Lordship.
This petition under Article 227, read with 227 of the Constitution of India, read with Section 151 of the Code of Civil Procedure. The petitioner has challenged the order dated 16/12/2024 passed by the learned civil judge junior division Bilasipara. An application filed under Order 47 Rule 1, read with Section 114 of the CPC. Whereby the pair for review of the order dated 18/3/2020 was dismissed.
Review of 4/3/2020.
Okay. 4/3/20, this is corrected later on.
Yes, Lord.
4/3/2023 was dismissed.
4/3/2020, Lord.
2020, yes. It is also to, and also challenge the order dated 4/3/2020 passed by the learned civil judge junior division number 2 Dhuri entitled suit number 90 of 2015, whereby the learned civil judge senior division has rejected the period of adjournment and closed the evidence of DW. So Dekka,
My Lord.
you come to page number 2 of the amended first title.
Yes, Lordship.
This title suit is pending before which court?
Civil Judge
Bilasipara.
Junior Division, Lordship. I have Senior Division.
Bilasipara, is there any civil judge senior division at Bilasipara?
Lordship, let me.
No, Lordship.
Lordship, it is Munsif Court, Lordship. Civil Judge Junior Division.
But in the amended cost title, what you have mentioned?
Lordship, it is SR. Lordship, may kindly.
Lordship.
I have written that, Lordship. In page number 1, it is specifically mentioned Junior Division. But here it is written
No, you have challenged 2 orders.
2 orders, Lordship.
It appears that the next order was passed by the learned civil judge senior division.
That is, Lordship, again,
You make necessary correction. You have been given chance to make necessary correction and again you have done the same thing. Or Mr. B. Decker, learned counsel for the
Lordship,
petitioner, and Mr. Gogoi, learned junior government.
Lordship,
expert for the-
this is junior division is mentioned, Lordship.
Where?
It is junior division is mentioned, Lordship, in the same.
Later part. So, by the order dated 9/6/2025, Mr. Decker was allowed to make necessary correction in the cost title. Yet, and he submitted the amended cost title. Yet it appears that in the said amended cost title also again some mistake crept in page number 2. Accordingly, it was directed that Mr. Decker shall make necessary correction in the cost title. List after vacation.
Monday.
Is there any urgency?
Lordship, this matter is fixed for hearing, Lordship.
It appears from your conduct that there is no urgency. After vacation.
Obliged.
Item 5.
Wait, please, your lordship. My lord, here petitioner is aggrieved by the order dated 5/5/2025, my lord, page 25, passed in title execution case number 13 of 2024 in title suit number 48 of 2018. Here, my lord, petitioner is ready to pay the decretal amount, my lord.
Installment.
My lord?
In installment.
Yes, my lord. He is a poor.
But where is the provision?
My lord, for natural justice, because he has no income,
no.
he is a ill
There is a
person.
provision in CPC. Have you gone through it?
I have gone through, my lord.
Yes. Which provision?
Provision, my lord. I have gone through, my lord. I think it is 21. But my lord, as he is a poor person, he has no source of income. He is ready to pay, my lord. Some time is required. Moreover, my lord, the property which is given attachment, he is homestead land, my lord. He is living with his family, mother and brother. It is in the name of 3 persons, my lord. And in the title suit also petitioner was absent. He has come to know only in title execution case. So I am praying for some time, my lord. He has filed petition, my lord.
So what is the total amount?
My lord, main amount was 5 lakhs, my lord. But 6% interest is there, my lord. It will be more than 6 lakhs, my lord. 6 lakhs, 61,000. So, my lord,
You go through order 20 rule 11 and therefore come back after some time. We'll take it up after some time.
Item number 6.
May I please, your lordship? My lord, the matter may pass on for the time being. My senior advocate busy in another court, my lord.
Who is your senior?
Mr. B. Chanda.
Item 7.
May I please, your lordship? My lord, in this matter, what happened, a probate case was filed by the petitioner's predecessor in introduced, arraying the other relatives and the brothers and sisters of the testator. And if your lordship come to page 18, that is the probate suit file. Here, one of the sister, that is the defendant number, opposite party number 8, she expired. And after his death, her death, her daughter, only daughter, was substituted in the probate title suit on 4th of March 2022. Thereafter, when the suit was proceeding, we took steps upon the substituted defendant number 8A. If application was filed by 2 persons, the of respondents herein, which your lordship will find at page 27. That application was filed under order 22 rule 4 read with Rule 3 and Rule 15 of Order 32 of CPC for their appointment as guardian ad litem of substituted.
Mr. Dhor, you have no grievance against.
No, I have no
appointing
grievance,
of,
but the only thing is that the learned trial court has implemented the two of them as main party to the proceeding. That is not permissible under the law.
Hmm.
Your lordship will kindly see the impugned judgment, which starts from page 47.
Hmm.
I just show your lordship page 51. Just two paragraph 9.
Hmm.
We have no grievance against them because she is admittedly mentally unfit.
Hmm.
Apparently, the petitioners are relatives of Srimati Barnali Medhi and they have been looking after her. Petitioner Rajesh Medhi is her maternal uncle and presently she is residing with him. Under these circumstances, petitioner Sri Rajesh Medhi appears to be the fit person for appointment as guardian and litem and for Ms. Srimati Barnali Medhi. Accordingly, Sri Rajesh Medhi is appointed as the guardian ad litem of Srimati Barnali Medhi. We are not aggrieved by that. That is,
Hmm.
so we accept it. The next
Second
paragraph.
part.
Next paragraph.
Hmm.
The petitioners, there here comes the two petitioners, the two respondents. Petitioners, namely Sri Rajesh Medhi and Kingshuk Medhi, are substituted as defendant numbers 8A and 8B respectively, along with Srimati Barnali Medhi, in place of the deceased defendant number 8, Srimati Barnali Medhi, with this Bandana Medhi, that is the mother of the Barnali Medhi.
Hmm.
So she was already substituted. One hand, the planet court below appoints one Rajesh Medhi as a guardian ad litem,
Hmm.
and on the other hand, appoints substitutes these two respondents as main respondents in the probate suit. That is not permissible in my submission. In fact, my lord,
Okay, let notice go at this essay.
in the matter, this order
We'll
may
see,
not be-
yes, heard Mr. A. Dhor, learned counsel for the petitioner. This petition under Article 227 of the Constitution of India, read with Section 115 of the Code of Civil Procedure is the petitioner has challenged the order dated 5/5/2025 passed by the learned additional district judge number 2 Kamrup M. Guwahati in title suit number 5 of
PPS.
2018.
probate text.
Probate titles suit number 5 of 2018. Under the provision of order 22 rule 4, read with order 32 rule 3 and 15 CPC. The petitioner is aggrieved by the order dated 5/5/25 by which the learned trial court has appointed, no, has substituted Rajesh Medhi, one Sri Rajesh Medhi and Kingsuk Soduri as defendant number 8A and 8B, along with Srimati Barnali Medhi in place of deceased defendant number 8, Srimati Bandana Medhi. Mr. Dhor, learned counsel for the petitioner submits that Sri Rajesh Medhi is appointed as guardian ad litem of Srimati Barnali Medhi, who has been suffering from schizophrenia. Then, thereafter, the learned trial court has substituted Rajesh Medhi and one Kingsuk Soduri as the defendant number 8A and 8B in the title suit number so and so, probate title suit number so and so, which is illegal and arbitrary, and therefore Mr. Thor contended to set aside the aforementioned part of the impugned order. The submission of Mr. Thor needs further consideration. At this instance, notice be issued to the respondents returnable in 4 weeks, that be taken by registered post with AD and also by usual process within a week from today. and pending further consideration by impugn order dated so and so. So far, it relates to substitution of Sri Rajesh Medhi and King Chaudhary as defendant number 80 and 8B in the probate title suit number so and so instances that will returnable to the list of records.
Obliged, my lord.
38,
Honor, Mr. R. Senso is currently on the legs in court 23, maybe taken after something.
39,
Please, your lordship. The matter relates to an order passed by the learned district judge acting as the election tribunal under the Panchayat Act. The challenge to the election petition was premised on the ground that in the result that was published after the election, there was discrepancy in the sense there was a difference of 4 votes. And the fact remains that the returned candidate and the election petitioner stands at a difference of only 1 vote. The dispute is with regard to the anomaly as regards the other 3 votes. There is no indication in the result sheet or anywhere else as to whether those were valid votes or invalid votes, rejected or not. So in that premise, my lord, the election petition was filed. If your lordship will kindly see the first result sheet, that is at page 21.
Yes.
Page 21 indicates, it's a translated copy. It indicates that 137 votes were polled by the person at serial 2, who is the return candidate. And the election petitioner polled 136 vote. There is only difference of 1 vote. Now, in the down below, your lordship will find the total is given like this. Total votes received 137. Total vote 383. Invalid vote, including 1 postal vote, 4. And total vote cast is 387. This is the first result sheet that was given to us on the day of declaration of result. Now, in this result sheet, we sent certain anomalies in the sense that the total of the votes polled, that comes out to 384, not 383. Total of the votes polled by the 4 candidates, that comes out to 384, not 383. So that was when there was an anomaly that was sensed. Subsequently, an RTI application was filed. And in response to the RTI application, my lord, at page 27, your lordship will see the reply.
Yes.
Now, in page 27, your lordship will find the total number of vote polled, 384. Whereas in the page 21, it is indicated as 383. So basically, there is a difference of 1 vote. Now, whether that 1 vote and the number of cancelled votes, your lordship will find as 4. It is at page 21 also it is 4, page 27 also it is 4. But there remains a difference of 1 vote. And that is the margin by which, my lord, I have been defeated. Now, what has happened to this 1 vote, that is the subject matter of controversy, whether it has been polled by me or it has been polled by the elected candidate, the returned candidate. So in these circumstances, I filed applications before the authorities for recounting of votes because the margin is only of 1 vote and there appears that this 1 vote has not been taken towards counting the cancelled votes. Apparently, my lord, there is a discrepancy in the sense that the response of the authorities are not clear as to whose favor this extra one vote has been counted? Or why it has not been counted? Now, in that circumstance, my lord, I approach the learned election tribunal, which is in the court of the learned district judge at Dhubri. And therein, a prayer was made that the oath taking is scheduled tomorrow, that is 21st. An interim prayer was made that at least this should be kept under suspension. The learned tribunal has passed the order at page 38, 39, 39, but has not even disclosed whether or not my interim prayer has been considered. Had it been considered and rejected, then possibly I could have some other remedy. But it has neither been considered nor rejected. Now, the result is that, my lord, if the oath taking is done tomorrow without there being any intervention, then it has the effect of potentially affecting the result of the election. Because it has to be ascertained as to in whose favor the people's mandate was there.
Yes, Mr. Dubey?
Meet please, Your Lordship. My lord, coming to the merit of it, my lord has seen in both the results which has been shown as well as RTI, there is a difference of one vote. The question remains as regard one. So that is a disputed question of fact that has to be determined. My lord, on the very first date, my lord, there can't be recounting. Notice has to be issued, which has been done rightly by the court below. And my lord, once response are received, then only my lord, this counting can be done. My lord, as things stands, my lord, the petitioner is one vote less than the private respondents. So this doesn't call for any interim order, my lord. My lord, my other issue is, my lord, this CRP is not maintainable. Because so far as election petition is concerned, my lord, writ petition lies, my lords, and therefore, my lord, it's not a proceeding under the CPC, my lord. Therefore, 227 is not maintainable. In other cases, my lord, your lordship has passed orders when the petitioner comes either for interim order or the final order under 226. Your lordship sees this is a petition under 227.
Hmm.
So 227 is not maintainable. There is supervisory jurisdiction in this case. If at all the petitioner ought to have come, they ought to have come under 226 minutes, which is generally the norms, because there is no appeal further provided. So the remedy is once any order is passed, against that 226 would lie before this one.
No, in the act, no remedy is provided.
No. And my lord, election matters pertain to bench 4 and bench 5, my lord. So, depending upon the my lord, relief sought.
But this interim order is passed by a
Civil court.
passed by a district judge.
My lord, it's
Whether
a,
writ petition would lie.
yes, my lord, it's an election tribunal. It's not by a civil court. It's a tribunal constituted under the Act in consultance with Honorable High Court. So it's not exercising a jurisdiction of a civil court, lordship. This is exercising a jurisdiction of tribunal, election tribunal. And there have been instances in past.
That's a debatable question.
No, this is absolutely clear question, my lord. This is not an issue. Debatable is whether he gets 137 or 138. That is debatable. It's crystal clear. His difference is one. Now, your lordship, any court passes an order, then it has to be presumed that the other party or the petitioner has got more votes. So we can't act on presumptions, my lord. That has to be come from the record. And on the first day, my lord, what has been done is rightly done, my lord. Notice has been issued. It's not that election petition has been said to be not maintainable. And the very first day, my lord, this kind of relief may not be entertained, my lord, because there is no material and record on part of the petitioner also. It's all a guessing game, my lord.
It's not a guessing game, my lord. It is based on the records provided by them. But they cannot say that it is a guessing game.
That has to be decided later on, but the question is whether this petition is maintainable or not.
Now, my submission would be, my lord, the district judge acts as a tribunal, that is correct. Under the act, my lord, district judge acts as a tribunal. Question is whether a writ will lie from this honorable court to another court. My lord, as I understand, my lord, even a writ from one bench to another bench does not lie. Now, in circumstance of this nature, where I am coming, my grievance is non-consideration of a prayer by the learned court below. Now, it's in such a circumstance, my lord, whether it will be a writ jurisdiction that I need to invoke, or I can come under 227. My lord, these are not mutually exclusive. Even if I can come under 227, there cannot be any bar that I cannot come under 227. Because 227 is the general power of superintendence which your lordships exercise over every subordinate courts and tribunals. So 227 is more pervasive, my lord, in a sense that it is not restricted to issuance of merely one or of the 5 other writs. The power of superintendence is not mutually exclusive with the 226, that in case 226 applies, then 227 will not apply. It cannot be a situation like that. The question that your lordships have to decide in the matter is that whether non-consideration of a prayer is jurisdictional error or not. That is my case in the instant petition. I made a prayer, and that is based on the records which have been furnished to me. It is not my creation. It has been furnished to me by the respondents. Now, on the basis of the records, my lord, that there appears that there is a difference of 1 vote, and that is very crucial in the sense that, my lord, the mandate ultimately it's a democratic process, my lord, where the people's mandate has to be given the utmost
just wait,
respect.
let us fix the matter at 2 p.m. In the meantime, I will consult with the registry. Let's see whether this petition is maintainable or not.
My lord, registry, I do not, my lord, ultimately, my lord, your
Whatever be, whatever.
With this respect to my learned senior friend, Lord, what submission has been made, it's a narrow campus, Lord. I would rather say, Lord, 227 is much narrower. Lord, there was a judgment of the apex court in, I think, 2006, 3 SCC. Lord, where, Lord, it was earlier held that non-consideration would come within the jurisdictional error. But that has been reversed by a 3 judges bench of the apex court, my lord, saying that in such matters, 227 will not be entertainable. And there had been instances placed before your lordship.
You produce the decision at 2 p.m.
Yes, my lord, that. My lord, just accommodate me for 5 or 10 minutes, my lord, because of other matters have been fixed at 2. I may come at 2:15 or 2:10 sometime.
Okay, all right.
Coming item 5.
God bless, brother.
Yes, madam, you have gone through the same.
Yes, my lord, order 21, my lord, rule 11,
Order
21.
order 21.
Yes, my lord.
21 or order 20 or rule 11.
Yes, my lord.
Which one?
Yes, my lord. Rule 11, my lord.
Art Miss
Yes, Bora.
as Borough Learned Counsel. This petition under Article 227 the Constitution of India, read with section 151 of the Code of Civil Procedure. The petitioner has challenged the order dated 5/5/2025 passed by the learned Civil Judge Senior Division, Nagaon. It is so noted here that by the been order dated so and so, the learned Civil Judge Senior Division, Nagaon has dismissed the petition number 106 written bracket 8/2025 filed by the present petitioner for allowing him to deposit the decretal amount in installment. The learned counsel for the petitioner submits that the petitioner is the judgment debtor In the title, so bearing number 48 of 2018. And in the said title, so was decreed by the learned court directing the allowing the plaintiff to recover a sum of rupees 5 lakhs from the present petitioner with interest at the rate of 6% per annum from the date of filing of the suit till the realization of the critical amount. So what is the ground for which you cannot make payment of the entire amount in one installment?
My lord, I have given my lord in the petition, my lord. Because the petitioner is a, my lord,
Paragraph number?
page 22, my lord, annexure 1. Petitioner is a, my lord, drug addicted as well as alcoholic person. At present, he is admitted in the rehabilitation center for his recovery. He is a professional diver and due to his addiction, he has no permanent source of income to maintain himself and his family. The petitioner is a law-abiding person. He is ready to deposit the decretal amount before the honorable court on partly basis. Due to financial hardship, petitioner is not possible to deposit the entire amount in one time.
The learned counsel for the petitioner submits that the petitioner is a driver by profession. Driver by profession, and he is a drug addicted person. And often he resides in a rehabilitation center for his recovery. And as such, he is not in a position to make payment of decretal amount, that is rupees 6,61,892 in one go. And besides, he has to maintain his family. And as such, it is contended that the petitioner may be permitted to deposit the aforesaid amount in installment. But having heard the submission of learned counsel for the petitioner, I have carefully gone through the petition, the documents placed on record, and also perused the order dated 5/5/2025. And it appears that the learned civil judge senior division has dismissed the petition on the ground that there is no provision for part payment of the decretal amount mentioned in the decree passed in title suit bearing number 48 of 2018. But it appears that there is a provision in the CPC rule order 20, rule 11, which provides that decree may direct payment of installment. Where and in so far as a decree is for the payment of money, the court may, for any sufficient reason, incorporate in the decree after hearing such of the parties who shall appear personally or by pleader at the last hearing, before judgment, and order that bracket closed, payment of the amount decreed shall be postponed or shall be made by installment, with or without interest, notwithstanding anything contained in the contract under which the money is paid. And subsection 2, and or rule 2, sub-rule 2 provides for order after decree for payment of installment. After the passing of any such decree, the court may, on the application of the judgment date, and with the consent of decree holders, order that payment of the amount decreed shall be postponed or shall be made by installment on such terms as to the payment of interest, the detachment of the property of the judgment debtor, or the taking of security from him, or otherwise, as it think fit. From a perusal of the impugned order dated 5/5/25, it appears that the learned civil judge senior division Nagaon has failed to take note of the provision of several 2 of Rule 11 of Order 22 or Order 20. Order 20. Under such circumstances, this court is inclined to allow this petition by setting aside the impugned order dated 5/5/25 with a direction to the petitioner to approach the learned trial court again, learned civil judge senior division again by filing an appropriate petition. And on such petition being filed, the learned trial court, learned civil judge senior division shall consider the same in the light of the provision of sub-rule 2 to Rule 11 of Order 20. When the next date is fixed?
My lord, next date is fixed on the 25 June 2025 for report, but Nazir has not visited the place, my lord. 25 June.
Before, on the next date fixed. Next day. So, you go and file a petition
My-
there. The court will consider the
My
same.
lord,
Because there is a requirement for hearing the other side also.
my lord,
As because the other side is not available before this court,
my lord,
we have refrained from passing any order.
my lord.
In terms of this, CRP instance, this will. This
Like-
one is this itself.
Pending item 6.
May I please, your lordship? Lordships, in this case, my lord, the father of the petitioner and the respondents, the brothers and sisters, my lord. My lord, their father died on 12/6/2018, my lord. After about 6 months, their mother also died, my lord. That is on 2012/2018, my lord. My lord, the father was an employee of State Bank of India, my lord. And during her death, at the time of death, my lord, 2 younger brothers who were minor and other sisters were unmarried sisters were there, my lord. Therefore, for seeking, my lord, for getting family pension, my lord, and to take the petitioner, this present petitioner filed a guardianship petition for taking guardianship of the 2 minor sons, my lord. In that case, my lord, the learned court below has although allowed the guardianship petition, my lord, but committed an error, my lord, showing that the petitioner, respondent number 2 and 3 were the sisters, my lord, as married, my lord. Therefore, that order was not accepted by the department, my lord, and the petitioner filed a petition for rectification of the order, my lord. That rectification order was, my lord, dismissed, rejected, my lord, on the ground that although the
Rectification
of the
or review petition.
well, it was a petition under section 125 of CPC, my lord, 152 of CPC, my lord, for rectification of the order. Otherwise, the order was in my favor, allowed the guardian petition, but inadvertently that respondent number 2 and 3 has been shown as married, my lord. My lord, may I kindly peruse the impugned order, that is last page, page 36, my lord. May I read, my lord? Case record put up along with petition number so and so. By petition number so and so filed under section 152 of CPC, the petitioner has sought rectification of the order dated 28/11/2019, my lord. The rectification sought for is that in the order dated 28/11/2019, the opposite parties have been shown to be married when in fact they are unmarried. It is admitted, my lord, they are unmarried. However, considering the fact that the case is one of the guardianship and this court had allowed the guardianship in favor of the petitioner, this court does not see any reason to alter the order dated so and so, and as the petition stands dismissed, my lord. Well, as because they have been shown, my lord, married, my lord, they will not get the family pension, my lord. And moreover, my lord, one ex gratia amount also not paying by the department, my lord. And for this rectification, my lord, these things has been held up, my lord. And it is an admitted, my lord, that the petitioners, it is admitted by the court that the respondent number 2 and 3 were unmarried at the time, my lord. Another small inadvertent mistake, my lord, that is the date of birth of Dev Chanda, my lord, that is shown in two, my lordship will find that page at page 30, my lord. Paragraph 1, line number 3, my lord. My lord, Dev Chanda and Raj Chanda, whose date of birth is 2/9/2002, but it should be 2/9/2012, my lord. My lord, they will also get some pensionary benefit, my lord, family pension, as both the father and mother died, my lord. Therefore, this rectification is required, my lord. And in the same para where the learned code below has shown that, may I read, my lord? May I read the paragraph 1?
This order is not challenged in this petition.
Yes, that was challenged, my lord. Therefore, the impugned order has been passed.
Order dated 28/11/2019.
My lord, the challenge is not required, my lord, because the order was in my favor, my lord. Guardianship petition was allowed in my favor. But
Whether in the impugned order dated 28/7/2023, there is any indication for making necessary correction in this regard?
Yes.
Where?
Well, that is at page, lordship will find my petition at page 32, my lord, annexure H. May I read, my lord?
Which paragraph?
Paragraph 2, 3, my lord, and 4 also, my lord. When sister younger are made parties in the case, the opposite parties number 1 was married, and the opposite parties 2 and 3 were unmarried.
Regarding that date of birth.
My lord, the honorable court order, court's order passed on so stated all the opposite parties were married in para number 2, line number so. In fact, the only opposite party 1 was married in the case. The married and the opposite party 2 and 3 are unmarried, my lord. In such circumstances, the opposite party order did so in para the opposite party number 1.
Where you have mentioned about the discrepancy in date of birth?
My lord,
Date of birth.
date of birth is at page, my lord. Lordship will find the original order, my lord. Page 29, annexure G, and relevant portion it at page 30, first paragraph, my lord. Lordship find the number 3. The in fact, the project is shown brother minor Dev Chanda and Raj Chanda, whose date of birth is 2/9/2002. It should be 2/9/2012, my lord, and 20/11/2008. That is correct, my lord. I have annexed the birth certificate was also exhibited, my lord, in that has been considered, my lord. It is an inadvertent mistake, my lord.
So you go and file a petition there.
My lord, I have filed, my lord, but that was dismissed, my lord.
Review petition.
My lord, I have filed, that was dismissed, my lord. Then the father and mother died, my lord, and this younger elder son, my lord, he is taking all responsibility.
Mr. Sundar,
My lord.
sitting in revision, this court cannot make
CRP, IO, my lord.
correction.
Lordships can, my lord. So,
Pardon?
Lordships have the jurisdiction to.
Pardon?
My lord, lordships can pass, direct rectify the order, my lord.
So these clerical mistakes this court can correct under.
My lord, if
by
this,
exercising
my lord,
jurisdiction under Article 227.
my lord can, my lord. The honorable post in 227.
So, Mr. Sundar, you do one thing. We
My lord.
direct we grant you liberty to approach the trial court again by filing appropriate petition. Then we will direct the learned trial court to consider the same in accordance with.
Lordship, that can be. That.
Part Mr. P. Sundar, learned counsel for the petitioner. This petition under Article 227 of the Constitution of India. The petitioner has challenged the order dated 28/7/2022. Passed by the learned distinguished preside. in petition number 459 of 2013, file under section 152 CPC, seeking rectification of the order dated 28/11/2019, passed in Miss guardianship case number 13 of 2019. Mr. Sonda, learned counsel for the petitioner, submits that the petitioner is aggrieved by the order dated 28/7/2023,
Lordship.
by which the learned trial court has refused to submits that the petitioners herein were the applicant in the application under section 10 of the guardianship, right?
Lordship, guardianship, yes.
The petitioners herein file an application under section 10 of the Guardians and Wards Act 1890 for appointment of applicant as guardian of person and properties of the minor.
Under section 7, read with section 10 of guardianship and award act, my lord.
Under section 7,
Page number 17, my lord.
under section 7,
Read with section 10 of guardianship and award act.
read it section 10
10,
of
my
the
lord.
Guardians and Wards Act
My lord.
1890, and therefore by order dated 28/11/2019, the learned trial court has allowed the petition. And while allowing the petition,
Date
the
of birth of
learned
Devchandra.
trial court has made an observation that the applicant number, word applicant,
My lord, that is the opposite party, my lord. Opposite Shoma Rani Chanda and Santoshi Chanda, where Shona has been married, my lord. And Dev Chanda's date of
opposite
birth is
party
mistaken.
opposite party number 2 and 3 were married, but in fact, said opposite party number 2 and 3 are unmarried,
At the relevant time, my lord.
and thereafter, having noticed the discrepancy in the impugned order, the applicants have file a petition being petition number 459 of 2023 on 28/7/2023, but the learned trial court by order dated 28/7/2023 has dismissed the petition on the ground that one of the case is one of the guardianship, and this court has allowed the guardianship within inverted comma guardianship in favor of the petitioner, comma. This court does not see any reason after the order dated 28/11/2019, and as such the petition is dismissed. Mr. Sondal submits that the observation made in the order dated 28/11/2019 that the opposite party number 2 and 3 are married, and in fact they are unmarried, and the said observation of the court deprive of them from getting the ex gratia amount on account of death of their
Father, my lord.
father, and also in getting family pension.
Family pension.
Family pension. Then as such, there is a requirement for making necessary correction in the order dated 28/11/2019, and also in the order dated 28/7/2023. Taking note of the submission of learned counsel for the petitioner and also considering the facts and circumstances on the record, this court is inclined to dispose of this petition, granting liberty to the petitioner to approach the learned trial court again by filing appropriate petition and with supporting documents. And in the event of such a petition being filed, the learned trial court shall consider the same in accordance with law. In terms of this, CRP, I will sense disposal.
My lord, date of birth, the Dev Chanda may also be rectification. That one observation. Otherwise, that will not be done.
Along with the date of birth
Of Dev
of-
Chanda, my lord.
of
Dev Chanda.
Deb Chanda. The opposite party number?
This is the minor, my lord. He is the minor. His guardianship was sought for, my lord.
Okay. Of
His
the
actual
minor-
date of birth is,
Of the minor.
my lord.
Okay.
Actual date of birth is, my lord. 2/9/2012, my lord.
Pending item
Obliged, my lord. Deep obliged.
38.
Please, my lord. My lord, I have approached this honorable court for on being aggrieved by an order dated 15/3/2024, my lord, passed by the learned executing court, that is the learned civil judge junior division Hibokagor in a misapplication, my lord, number 108/2023, my lord. Originally, the suit was, my lord, filed by the respondent herein. I was the defendant therein. I have appeared and I have filed a counterclaim, my lord. And the suit was decreed in my favor, my lord. When I filed the execution application, my lord, there is some discrepancy as regard to the, my lord, the boundary was found. Accordingly, my lord, page number 12, my lord, this application was filed before the learned executing court, my lord.
No, on the other day, you have been asked to show me the provision.
Yes, my lord.
whether
May I please place a
after a
judgment?
decree being passed,
Yes, my lord. May I
the
please,
boundary of the property can be changed.
my lord, may I please place a judgment, my lord? Round one, my lord. Paragraph number 17, my lord.
On what ground the petition was dismissed by the executing court?
My lord, only on the ground of, my lord, the non-maintainability. My lord, page number 19B, my lord, the last paragraph.
Page number?
19B, my lord.
And that is the order.
Yes, ma'am.
Where is the operative portion?
This is the operative portion, my lord.
Number?
Page number, my lord, starts from 19B, my lord, the last paragraph. 19B.
Or Mr. R. Sensual, learned counsel for the petitioner. This petition under section 115 of the Code of Civil Procedure, read with Article 227 of the Constitution of India. Read with section 151 of the Code of Civil Procedure. The petitioner has challenged the order dated 15/3/2024 passed by the learned civil judge, Junior Division Sibsagar in Mincy case number 108 of 2023. Arising out of title execution case number 1 of 2018. It is to be noted here that by the June order dated so and so, the learned executing court has rejected the petition filed by the petitioner under Order 6, Rule 17, with Section 151, 152, and 153 of the Code of Civil Procedure. Mr. Sensual, learned counsel for the petitioner submits that the petitioner is the degree holder in title execution case number 1 of 2018. And during the pendency of the title execution case, as per report of the Nazir,
My lord.
where is the report of the Nazir?
But that is not here, my lord.
The decretal length along with the boundaries as mentioned in the counterclaim measuring 3 kata, but the decretal length is found to be of 2 kata. And the boundary and the boundary in the northern side of the schedule of the counterclaim is also found to be different from that of the counterclaim. And thereafter, the petitioner has filed a petition under Order 6, Rule 17, along with Section 151, 152, and 153 CPC. But the learned trial court has, the learned executing court has dismissed the same on the ground that allowing the amendment as prayed for by the petitioner as it on the basis of material facts as stated in the written statement and counterclaim by the petitioner struck defendant that the court has pronounced its judgment as well as the decree. And therefore, and thereafter the learned executing court has dismissed the same. Mr. Censor, referring to a decision of Honorable Supreme Court in Fortiva Singh and others versus Santi Devi Prasad and others, reported in Mono stroke SC stroke 1098 of 2002, especially to paragraph number 17 on its left. When the suit is to immovable property has been decreed and the property is not definitely identified, the defect the court record caused by overlooking the provision contained in Order 7, Rule 3, and Order 20, Rule 3 of the CPC is capable of being cured. But while passing the interim order dated so and so, the learned executing court has overlooked the aforementioned provision. And as such, the interim order overlooked the aforementioned provision, but it has only taken note of the provision of order 6, Rule 17. Reviewed section 151, 152, and 153 CPC, and on such count, the interim order dated so and so fails to withstand the legal scrutiny, and therefore Mr. Censor contended to set it aside. The submission of Mr. Censor received due consideration of this court. I have also carefully gone to the petition and the documents placed on record, and also perused the interim order dated so and so, and also the decision of Honorable Supreme Court in Procedural and others within brackets Supra, especially in paragraph number 7. Taking note of the submission of Mr. Censor, and also considering the facts in the record, and also taking note of the decision of Honorable Supreme Court in the case of Procedural and others within brackets Supra, this court is inclined to set aside the interim order dated 15/3/2024 and to relegate the matter to the learned executing court to consider the petition of the present petitioner in the light of observation made by Honorable Supreme Court in the case of Procedural and others, especially in paragraph number 17. In terms of this, simply stands disposed of.
Acknowledgement.
When the next date is fixed,
About it was, 16, my lord, it was fixed on 16 last.
petitioner is directed to appear before the
16 July.
learned court on next date. Next fixed date, that is
16 July, my lord. Acknowledgement.
May it please the lordship. My lord, a title suit is going on, my lord, between the a title suit is instituted, my lord, between the petitioner and the respondent, my lord. The petitioner before your lordship is the defender, my lord, and the respondent was the plaintiff. I have annexed the plaintiff of the suit as well as written statement. My lord, in the meantime, during the pendency of the title suit, my lord, a quarrel was taken place, my lord. The plaintiff's party, my lord, suddenly attacked the petitioner, and his head injury was there. His head was operation, my lord. My lord, lordship may kindly come to page number 37, my lord. This is the FIR, my lord, during the pendency of title suit, my lord. 37.
so
This
along with the review petition, you have filed any medical document?
my lord, documents, my lord. That set of documents, my lordship may kindly see, my lord, page number 44 to 52, my lord. Page number 44, lordship may kindly come. Page number 44, the treatment was started from 6/11/2024 when the FIR was lost and the incident was taken place. Page number 44. Date is there, my lord. Page 44, 6/11/2024. My lord, actually, my lord, what happened, my lord? Page 45 may be seen, my lord. Page 45, advice column is there in the down below. Advice right hand side, nerve surgery is required, my lord. So head operation was there, my lord. Nerve surgery. My lord, the treatment was continuing, my lord. Page number 50 also may be seen, my lord. This is the report of 11th December 2024. Thereafter, my lord, he visited the hospital, my lord. Page number 51, my lord. 11/12/2024. repeatedly till now he is under treatment. Lordship, lastly, Lordship may kindly see page number 52, my lord. My lord, this prescription, my lord, dated 15/2/2025. My lord, he is not recovered till now also because his neurological problem for head operation, my lord. So, my lord, in the meantime, his wife, my lord, submitted an application, page number 53, submitted an application for on medical ground, my lord. My lord, this application was
Oh, you tell me whether Mujibur Ali and Mujibur Rahman are same person.
same person, my lord. Mujibur Rahman, actual name, my lord. Somewhere Mujibur Ali is there. Actually, both the parties are own brothers, my lord. Own brothers. Due to a plot of land, my lord, dispute was taken place. Petition was submitted. Page number 56 is the vernacular, my lord. Anzora Begum is the wife of.
You have examined any witness?
No, actually, that prayer is there, my lord. After submission of the written statement, my lord, the quarrel was taken place, my lord. He was under treatment, my lord. So the petitioner's wife, during the treatment, my lord, came to the court and
The evidence of the plaintiff's witness is completed.
my lord,
Plaintiff witnesses completed.
completed. So for the petitioner's witness, official witness is remaining, my lord. Official witness, my lord. So I prayed for a petition, my lord, page number 56, vernacular, my lord, submitted by the wife of the petitioner that her husband was under treatment. So an adjournment may be given on the next date, my lord. The witnesses may be
Who is
examined.
the official witness?
My lord, the only official witness is written here, my lord. Lordship.
Where?
My lord, page number 54, the prayer, para 3, my lord. From the above reason, another date may kindly be granted for evidence of official witness. This was the prayer, my lord. Page number 54. And
And how many
order.
witnesses? How many witnesses you have examined?
My lord, otherwise, that is not recorded here, my lord. Page number 59 is the order, my lord. Lordship may kindly see for a moment, my lord. Page number 59. Para number 8, the ground of rejection, my lord. Actually, all the documents were medical documents, my lord. Lack of medical document, para number 8. So, during the treatment of her husband, medical document could not be submitted, my lord. These were in the hospital.
On who is that you were in hospital?
Hospital, my lord.
On who is that?
My lord, hospital from my lord, page number 30, page number 44 to 52. My lord, I am coming. 6/11/2024 to 15/2/2025, my lord. 2025 February, my lord. So, my lord, the medical documents, my lord, certainly could not be produced, my lord. Thereafter, my lord, when the case was rejected, my lord, I have filed a review petition under 114 CPC, my lord. That is page number 60, my lord. Page number 60 is my review petition. My lord, review petition is page number 63. One ground may be seen, my lord. Several grounds is there, my lord. Page number 63, ground number B. For purpose of official witness to stop has a great impact on this case. Only on then giving testimony can the sides of parties be decided and the justice can be upheld and real rights of the parties decided. So, my lord, the important witness, my lord. Lordship may kindly see the order of the review petition, my lord. page number 66, my lord.
So you
Uh,
see, you have been discharged on 11/11/2024.
11/11/24, there was a
And
discharge.
this order was passed on 24/1/2025.
My lord.
How do you justify it?
Order was passed on 24/1/2025, and my lord, medical documents.
Discharge certificate
Discharge, sir, after,
11/11/2024.
my lord, discharge was there, but after that also, my lord, he was not completely cured, my lord. Page number 52 is a medical document. 15/2/2025 till 15/2/2025, he was bedridden, my lord. Page number 52. Due to head operation, my lord. Operation patient, my lord, directly cannot come to the court, my lord. Page number 52. This is a medical document, February 2015/2025, my lord. And my lord, the order was passed on 24/1/2025. During this time, my lord, he was totally bedridden, my lord. Page 59 is the order, my lord, as your lordship has seen, my lord. Thereafter, I filed a review petition that is rejected, my lord, page number 66, only on the ground that due to lack of medical documents. Medical documents could not be produced because all the documents were in the hospital, my lord. So, my lord, finally I filed a petition, my lord, page number 71 for a moment, my lord. Vernacular may be seen, page number 72. Only one line may be seen, my lord. This was submitted, page number 72, my lord, last line. ইয়াৰ লগত medical কাগজ গাঁঠি দিলো. So all the medical documents after recovery, my lord, medical documents were submitted, duly submitted. But my lord, without examining the witness, without arguments, my lord, the case is fixed for judgment, my lord. Page number 74, last page. Page number 74. Without evidence, my lord, examination of witness and argument, my lord, the case is fixed on 7/5/2025 for judgment, my lord. But liberty is granted earlier, para number 8, page number 74, for argument. So without examining the witness and argument, my lord, for proper adjudication of the case, my lord, it is not possible, my lord. So limited prayer before lordship is there. My lord, one opportunity may be given to examine the official witness. Only one date is required, my lord. Thereafter, judgment may be pronounced. That much limited prayer.
Who is the official witness?
Official witness to exam, my lord, that is not reflected here, my lord. I have annexed the entire order, my lord. Official witness, my lord, to examine the, my lord.
Who is he? Who is the official witness?
Official witness, my lord, it is not reflected, my lord. I have not taken instruction because office of the circle officer to examine the land documents, my lord.
Circle officer?
Circle officers, Mondol or like that, it may be, my lord. I am not sure, my lord. So
You
it is
obtain
not written,
necessary-
actually reflected in the,
You obtain necessary instruction?
my lord, after some time, I am taking the instruction, my lord. It's urgent
Yeah.
matter, my lord. After some time, my lord, I am taking the instruction.
After 2 p.m.
2 p.m, my lord.
Items for admission, item 8, corporate matter.
My lord, in pursuance to the order dated, my lord, 30/4/2025, I file affidavit and government also file affidavit, my lord. Regarding provincialization of my service, my lord, because my lord, it was turned down earlier, I have disposed this honorable court.
Page number?
I have submitted, my lord, my affidavit is started from, my lord, page number 76, my lord. start from 76, my lord. And the table I have given 78 page now.
Then what is the requirement for provincialization?
And provincialization equation, my lord, they rejected me because, my lord, last year, they interpreted the last year. Because in the act, it was says the last year, they says last year means 2016. But last year means when you consider that just before that. That is our, your lordship kindly see my rejection order, my lord. Reject order which I have impugned here, my lord.
Page number?
Page number, my lord. 59. Before that, my lord, I take to your lordship to the judgment passed by this honorable court earlier, my lord. I annexed the judgment, my lord. Because earlier I opposed this honorable court for non-provincialization of my service. The page 55, before, my lord, going to that impugn order, your lordship kindly see, my lord, page 55, my lord. Relevant portion is page 57, para 5. Page 57. This stated that the para 5, my lord, this stated that neither under Act 2011 nor under Act 2017, the author of Madhya Panduri Higher Secondary School in the subjects of Sanskrit has been provincialized. Section 3(1), subsequent section 7 of the Act 2017 provide for the at least one teacher of the tutor or tutor to be provincialized in each subject, which can also include the subject of Sanskrit. As none of above been provincialized in the subject Sanskrit till death in the Madhya Panduri Higher Secondary School, at a legal right flow from the petition under section 20. A respondent having not considering the petition for provincialization of the institution constitute that a higher legal higher under section 20 has been said. In the circumstance, we direct the Director of Secondary Education Assam to call for a record of the Madhya Panduri Higher Secondary School. Secondary school and verify whether any teacher has been provincialized in the subject Sanskrit, either under Act of 2011 or under Act of 2017. After verification of the record, it is found that we found that no teacher has been provincialized in the school for the subject Sanskrit, the director to pass a reason order after verifying the service particulars and eligibility of the petitioner. Either provincialization of the refuse to provincialize the service of the petitioner by giving a reason order. If the director find that the petitioner made all the eligibility criteria, no one has been provincialized in the subject of Sanskrit in the Madhya Panduri Higher Secondary School, appropriate order may be passed provincialize the her service. In that night, if the order had other hand, the director upon verification of the record may arrive at the conclusion that certain disabilities exist in respect of petitioner appropriate order may be passed by giving a reason or reason thereof. So in compliance to that order, my lord, your lordship kindly impugn order page 59 was passed. Page 59. Read and peruse the Honorable High Court order dated so and so. Whereas Srimati Kalpana Devi filed a case before this Honorable Court, the WPC number so and so, High Court passed an order dated 21/9/2021, directing the Director of Secondary Education Assam to call for a records and from the Madhya Panduri Higher Secondary School and verify that whether the teachers had been provincialized in the subject of Sanskrit either under Act of 2011 or 2017. If after verification of the record it is found that no teacher has been provincialized in the school for subject Sanskrit, the director to pass a prison order for the verifying the petitioner. Whereas the office vide order dated the inspector of school KDC Kamrup Aminga was requested to furnish the information as to whether any teacher has been provincialized in the subject of Sanskrit either in the as per section 2011 or 2017, along with detailed report with all 11 documents, that is DLSC report and the allotment DH so and so, the inspector of school so and so. Whereas the as per report received that the inspector of school KDC Kamrup is listening that the name of the Kalpana Devi was not recommended by the DLSC and enrollment of the Sanskrit subject during 2016 in has SSLC final examination was only 6. As per the Assam Educational Provincial Service Teachers and Reorganization Educational so amendment, the year 2016, the high school final examination. Alignment should be 10 in the year 2016 SSLC examination. On the above the fact and circumstance, the matter of provincial service will be responded in respect of the Kalpana Devi in Moita Pandit High School, Tamil direct could not be considered. So hence this. So my lord, your lordship kindly see, in 2016 there are no 10 students. That's why my case has not been considered. That's why my case was considered in 2023 or 2021. And they have taken my lord, what is the how many students appearing my lord 2016? Your lordship kindly see the act, my lord.
You show me the provision.
And
This Assam Higher
Yes, my lord.
Assam Education Provincialization Service and reorganization
Yes, my
of
lord.
educational institution, right?
Good, my lord. Yes. This act, my lord, I'll copy attention. This book, my lord, page 110, my lord.
Yes.
Page 110, subsection 7, my lord. For provincialization of service of one teacher or tutor, as the case may be in each subject, including the core subject in case of Bhansar Higher Secondary School or Bhansar Higher Madrasa or Bhansar Higher Secondary School or Bhansar Secondary School, at least 10 students must have appeared in the last final examination in the particular subject from that institution. Further, for provincialization of service of the maximum limit of the 3 teachers or tutor in a particular subject, as the case may be, in case of the Bhansar Degree College, at least 15 students particular subject must have been appeared in the last final examination for the last college. In case of college, 15, in case of my lord school, it is 10 last examination. So last examination, as I understood, my lord, when you consider before that. But here in the lordship kindly say, they say that 2016, we have no required student of Sanskrit. So I cannot be considered. We cannot consider it. So that's why in that context, my lord, your lordship, my lord, because I have given a table, 18, 19, 20, I have given, my lord. How many students? 18, 19, 20. Because my case was considered in 21. That's why in my writ petition, I have mentioned about, my lord, student, how many students appeared? Page 19, my lord. Page 19, my lord.
Yes, additional affidavit.
Page 9, yes. No, page 19 of the my lord, my writ petition, my lord. Page 19, my lord. Before going to my additional affidavit, I want to, my lord, show 18 to 19, 20. 18, 14 students appeared, 1916 appeared, and so and 2020, 23 students, my lord. So that was, my lord. Then your lordship in last order, let's say, asked me to furnish before that, my lord. So, that is, my lord, in 21, 22, 23. So now in my additional affidavit, I'll show page 78. Page 78, my lord. That is my additional affidavit, my lord.
Yes.
21, in the year 2021, 20 students appeared. In 22, 22, 23, 31, 24, 32, and 25, 24. So these are list, my lord, and that is supported by their affidavit also. They have filed, the government also filed an affidavit that is filed on 13/5/2025. That is filed by the inspector of school, Kamrup District Circle, my lord. That is probably, my lord, paginations are not correct, my lord. That's why your lordship kindly said last affidavit filed by the inspector of school on 13/5/2025.
Student number 2.
Paragraph.
Pagation book, ठीक नहीं हुआ।
Mr. Mohanto, it is of dated.
That is, my lord, it's filed on 13 May 2025. By the, yes, 13 May 2025 by Inspector of School, respondent number 3. Tapon Kumar Kolita.
Page 82, your lord.
No, 82 no hobo.
82.
No, 82 no hobo. 82 amar phone 82. But kafi kafi short hobo na. Amar phone short hobo na. Because I filed on.
Questions are wrong, your lord.
Open Kumar Kolita.
Yes, my lord.
Okay.
Para 5, my lord. No, para 4, my lord. No, they have given only, my lord, 18, 19 and 20. Last 3 years, my lord. No, although they have given from 14, but 19, 18, 19, 20 they have given. Itu ভুল হয়েছে না, itu print. There is a slight, my lord, typographical mistake, my lord. It so far is, my lord, Sanskrit 2020 is concerned, my lord. Please, has your lordship got it, my lord? Para 4, my lord. Para 4, my lord. They shown 2020, 10. How can I, my lord, if 10 appeared, my lord, 20 pass? That is 21 appeared, 10 pass, as per their annexure, my lord. Annexure A, my lord. 21 appeared and 20 passed. So last 6 years, that means, my lord, if your lordship from 18, 19, 20, and my lord, then in my affidavit, my lord, I have stated 21, 22, 23, 24, 25. All along, my lord, from 18 to till today, that is more than, my lord, 10 students appeared in all examinations. In all the year, my lord. So now, my lord, they considered in why they have considered in only 2016, my lord, how many, when in the year which when minimum was appeared, they have considered that. But as per the act, not last exam. What do you mean by last exam? Just before, my lord.
You saw me the provision?
Section 3, subsection 7, my lord. Subsection 7. For provincialization of service of one teacher or tutor, in the case may be in each subject, include the core subject in case of Vansar High School or Vansar Higher Madrasa or Vansar Higher Secondary School or Vansar Senior Secondary School. At least 10 students must have appeared in the last final examination in the particular subject. So that was the criteria, my lord. So your lordship kindly see, when may they reject me, but rejection order, your lordship kindly, rejection order is, my lord, 25th April 2022. 2022, page 59, my lord. Page 59. Page 59, my lord. I have read that order, my lord. Last but 2 para, my lord.
Yes.
Whereas the as per report received from the inspector of school, ADC, Kamrup, it seemed that name of the Kalpana was not recommended by the DLSC and the enrollment of the Sanskrit subject during the 2016 in SSLC, SSLC examination was only 6. So they have considered only that, my lord, 2016, my lord. The last, when you consider my case in 2022, after the judgment passed by this honorable court, this honorable court clearly mentioned that you go to the record and pass the order. So, my lord, only because, my lord, in 2016, only, my lord, 6 students appeared, that's why, my lord, they rejected my. So it is clear violation of that's the rule, my lord, the section itself, my lord.
So the director ought to have considered the enrollment
Of the last year means.
Last year means this order was passed
2022. 2022 plus 21. 21. Last year means 21.
The year of 2021.
21, my lord.
In the year 2021, what was the enrollment?
2021, 20 students appeared and 20 passed. And that's why, my lord, in the last order, your lordship asked me to provide that, my lord, and I have given that page 78, my lord. Page 78.
Okay.
So
Yes,
that is my
madam.
question.
May I please, Your Lordship? Okay, regarding the interpretation of section 3, Your Lordship, section 317, Your Lordship. A coordinate bench has already decided the matter, Your Lordship. Lordship, I'd like to place the decision. Lordship will peruse paragraph 1, Your Lordship. May I read, Your Lordship? The short question which has arisen for consideration in this writ petition is with regard to the interpretation of section 317 of the Assam Education Provincialization of Services of Teachers and Reorganization of Education Institutions Act 2017 for the issue of provincialization of the service of teachers, tutors in Venture Higher Secondary School and the fulfillment of the conditions of such provincialization, Your Lordship. And the relevant paragraph is at paragraph 12, Your Lordship.
Yes.
The rival contentions advanced by the learned counsel for the petitioners have been duly considered, and the materials placed before this court have been carefully examined. The relevant provision of law has already been extracted above. The controversy in this case is only with regard to the meaning which can be assigned to the expression last final examination. The expression used, namely last final examination, is not qualified by any other provision which may give the department to contend that it is the examination held in the previous year. When the statute in question is plainly worded, there is no scope to give any other meaning than the one which appears from a plain reading of the statute. Under the principles of interpretations of statute, it is the plain meaning which is required to be taken into consideration unless such plain reading does not make any reasonable construction. In the instant case, there is no dispute with regard to the fact that the examination of the higher secondary examination of the year 2017 was held between February 2017 to March 2017. And the expression used in the statute is with regard to the appearance of at least 10 students. The department has not disputed the data produced in this case with regard to the number of students which have been projected to be 13. Under those circumstances, this court is of the opinion the denial of the benefit of provincial service by giving an incorrect meaning to the provision of law is not at all justified, Your Lordship. So here the last examination, the year that has been considered is from the date the act had come into force, Your Lordship. And Your Lordship, section 1, section 1 says that when will it come into force? It will come into force as such date as the state government may by notification in the official gazette appoint and different dates may be appointed for different provisions of the act or for different category of education institutions. And Your Lordship, 7317 was amended, Your Lordship.
When?
And it was published on 18th May 2018. Down below, Your Lordship, in the act, down below, it has been, there has been a star mark. Substituted clause 7 by the Assam Education Provincialization of Services, Teachers and so Amendment Act 2018, published in the Assam Gazette Extraordinary Number so dated 18 May 2018, Your Lordship. So the last examination will be, Your Lordship, 2017, Your Lordship. And it has been interpreted in this, the judgment that had placed, Your Lordship. Because Your Lordship, a base year has to be considered. And the base year will be from the day the act has come into force. Only because, Your Lordship, the petitioner has submitted her application on in the year 2020. Whether will that be the base year, Your Lordship, that has to be considered. Because for different teachers, base year will be different. And if in that way it is interpreted, Your Lordship, then the provisions of the act It may not serve the purpose, your lordship. And your lordship, if your lordship sees the other provisions in section 3, your lordship, if your lordship sees clause 5, your lordship, the venture education institutions has a minimum total enrollment of 25 students in class 10. If it is a venture high school, 25 students in class 12. If it is a venture high secondary school or a venture junior college, 30 students in the final year of the 3-year degree course. If it is a so as on the date of coming into force of this act. So there, here it has been specifically mentioned as on the date of coming into force of this act. And similarly, in 6, your lordship will see, in case of a venture high school or a venture high secondary school or a venture junior college or a venture degree college, the concerned venture educational institution must have a consistent good academic performance, which should mean that at least 30% of the candidates appearing for the final examination as a whole must have appeared in the last 3 consecutive examinations held during the previous 3 consecutive years prior to the date of coming into force of this act.
No, here the relevant provision is,
317, your lordship.
yes. Yes. But, can it be said that, in paragraph number 12, a coordinate bench of this court has laid down any law to be read as a precedent?
Lordship, because there the issue was whether the last year exam will be counted from, because that school was provincialized in the year, your lordship. If I can remember, it was provincialized in 2021, your lordship. 2021, and the person was not considered. In 2021, the school was provincialized in the year 2021, your lordship. And your lordship, and there are other provisions like in section 4, your lordship. Section 4 of the act. Teachers or tutors to be government servants, your lordship. So here the provision is 4 clause 4. In case of teachers and of tutors of the schools for special subjects like Sanskrit, Arabic, Hindi, craft teacher, music teacher, and so, the number of students appeared in the concerned final examination like HSLC and HS conducted by the SEBA and so as the case may be, shall not be less than 10 students in each class per year during the last 3 years.
Last 3 years, when the director has considered her case?
Not sure.
In
So,
the year
here-
2022, then immediately before 3 years of 2022, then.
Not sure. But and your lordship, here there is a procedure for provincialization of a teacher or a tutor. Now see, the procedure is later on 13 because their name has to be
No,
recommended.
madam, even if we go by this paragraph number 12 of
Yes,
this
yes.
judgment,
Lordship.
here the year is considered as 2017,
17.
but the director has considered it as 2016. Is
16.
it correct?
In that case also, in the one that I've placed, your lordship, there we had, in our affidavit, we had said that the year should be 2016. But the court had, but the coordinate bench has said, no, it will not be 2016, it will be 2017 because the act was amended in 2018. So that's why the base year will be 2017, your lordship. And that school was the one that I have placed, your lordship, that was provincialized in the year 2021.
Mr. Monto, have
My
you
lord.
gone through this paragraph number 12 of his decision?
No, yes, my lord, I have gone through it, my lord, but it is in what context, my lord, I do not know, my lord. I have to go through the petition also. And my lord, your lordship kindly see that there is no reference to the 2018, my lord, amended rule. When 2018 it was amended, my lord, your lordship kindly, that is also same thing as the last year. If it is 2018 rule, they will consider my case as per the 2018 rule, because not 2017 rule, my lord. It is amended in 2018. In 2018, my lord, that my lord, in 2018 February. Suppose if your lordship interpreted this judgment, my lord, then it will be the February 2018. It will be February 2018, my lord.
And, what is the enrollment in that particular year?
Yes, my lord. 2018, my lord, examination, my lord, is 14 student, my lord, appeared,
More than the required number.
my lord. So in my affidavit, my lord, I have clearly stated, my lord, they also, my lord, stated, my lord, 14 student is there. My lord, that interpretation, my lord, I have to see that, my lord, whether that, my lord, what context with that. But then if it is, my lord, last year means, my lord, that that is only, my lord, is one time, my lord, one time procedure, my lord. Then after that, there will be no provision, my lord.
There shall not be.
There shall not be, my lord. There's a constant. That means
Perhaps that interpretation cannot be
My lord.
given effect to.
no, question of, my lord, that, my lord, probably that context of that case, my lord, that particular case. But otherwise, my lord, what I understand, my lord, if it is, my lord, last year in 2016, then, my lord, that is one time use of that act, my lord. After that, my lord, there is no.
Had it been the intention of the legislature,
Yes, my lord.
they would have given the year 2016 specifically, not last year.
Yes, exactly, my lord. The word last, instead of word last, it should be in 2016.
16.
Specifically should have mentioned, my lord. That is not done there, my lord.
Number 16, 2016 cannot be given your lordship, because if you see, the act shall come into force on such date as the state government may by notification in the official gazette appoint and different dates will be appointed for different provisions of the act. 2016 cannot be specifically given because here the act was amended.
No, no.
No, that particular
Very-
clause.
Even 2016 as the last year. In the impugn order, it has been mentioned as 2016.
16, your lordship.
Yes.
But if we go through the decision that I have given, your lordship, by the coordinate bench, it has been decided that it will be 2017.
17.
17,
But
your
thereafter, this amendment has come into force.
2018.
18 it has come into force, your lordship. There our argument was that even though it has come, the specific provision has come into effect in 2018, we will take the base year as 2016. And in that case, the court has said that no, it will not be, because the act was amended in 2018. It has come into force in 2018, and therefore the base year will be 2017. The last examination will be counted from 2017.
No, 2018.
So, Mr. Monta, what was the enrollment in the year 2017?
2017, my lord. Yes, 2017, my lord, there is only 4 students, my lord.
But it is difficult to accept that last year means 2017 or 16.
My lord. Suppose my case is considered in 2030, suppose. Because nowadays, my lord, Sanskrit is, my lord, very major subject, my lord, and day by day students are increasing, my lord. And 2013, they say, no, in 2016, 4 students, so you cannot consider. But can it be, my lord, justified, my lord? So, my lord, and under what, my lord, actually, what context this judgment was passed, and probably that judgment, my lord, fit to that particular case, my lord. I have not gone through the provisions of the entire petition, my lord, of the case judgment, my lord. So, let me, my lord, verify it, my lord, but that is, in a common sense, my lord, is unable to accept it, my lord. Last year means, because it is not the intention of the legislation, my lord. If it is intentionally registered in that particular clause, yes, last year means so and so. That has to be mentioned, my lord. Otherwise, my lord, that one time use of that clause, my lord. I mean, after that, nobody will be, my lord. That means that whenever you consider for provincialization, you have to see, look to down 2016 only. If it is fixed on that, my lord. That's why instead of last, they should have, my lord, 2016. Then, my lord, I have no case, my lord.
No, in that case, in future, no one.
My lord, then that means one time use of that section only, my lord. Because nowadays, your lordship can see simultaneously increase number, my lord. Now it's just 20, 21, my lord, 24 student, 25 student, my lord. And they will suffer, my lord. In Sanskrit, this Sanskrit, my lord. And now, if it is, my lord, there is no teacher, then, my lord, definitely school, my lord, gradually student will, my lord, not be appeared. So that is the.
Let us do one thing.
My lord.
We'll fix it before vacation, any date. In the meantime, you go through the
My lord.
petition.
My lord. No, not before vacation, after vacation, my lord.
After vacation.
After vacation, because last week, my lord,
And
probably.
also regarding this interpretation.
My lord.
Last year.
Last year interpretation.
Last year interpretation. Uh, So, in respect of provincialization of this elementary under that act,
My lord.
there is specific mention that Dias code should be there in the year
Lordship,
2009.
No, that
What
school
secondary
was,
is not
school was provincialized by the under the 2011 Act,
11.
2013.
13
Yes.
Act.
The school was provincialized in 2013, my lord. Thereafter, 2011 had
No,
gone.
there the year is specifically mentioned.
Yes, sir.
My lord, I'll that context. Yes, my lord. I'll see, my lord. Yes.
But here,
Here, not,
nothing mentioned
here, my lord, last year.
last year.
So if
Whether
it is
last
mentioned as
year
a last year, it will be very
interpreted
minor.
as 2016 or 17,
My lord.
whatever be that.
My lord.
Then let's look, see. Art, Mr. Monto, learned senior counsel assisted by Mr. Learned counsel for the petitioner. And Ms. P. Musahari, learned counsel for the respondent. Art in part, list the matter on COVID, accept it.
1st July.
21st July.
My lord, no problem.
Obligation, Lord.
Number 9.
May please your lordship. Lordship, this is an appeal against an order of the Learned Commissioner for workers' compensation. Lordship. The amount to the award is in page 14, Lordship, 3,12,164.
Page number?
14 of the memo, Lordship. Judgment page 7.
What is the quantum?
3,12,164.
When the accident took place?
Lordship, yes.
When the accident took place?
Accident took place at Borpeta, Lordship. It's a bridge at Borpeta. From Canada towards Buggles Road. Under
23. 19/12/2023.
on date, Lordship. I was looking at the place. I'm sorry, Lordship.
Art Mr. Argusami, learned counsel for the appellant. This appeal under section 30 of the Employees Compensation Act 1923 is directed against the judgment and order dated 2/4/2025 passed by the learned commissioner for the employees compensation forfeiture in EC case number 222 of 2024. It is to be noted here that by the new judgment and order dated so and so, the learned commissioner has directed the appellant herein to pay sum of rupees 3 lakhs
12,164.
rupees, being the compensation to the respondent number.
There's no one, Lordship.
Respondent number 1 herein, this petition. Peruse the memo of appeal and the grounds mentioned therein. Admit. Issue notice to the respondents returnable in 4 weeks that be taken by registered post with AD and also by usual process within a week from today. Register shall call for the record from the learned commissioner. Fix the matter after 4 weeks. IA
I is there for.
50%.
Problem, Lordship.
Number 10.
Please, your lordship. Here, my lord, the check issued by the owner of the vehicle, my lord, for entering into the contract of insurance got dishonored, lordship. As a result, the contract became void ab initio, and the accident took place after the cancellation of the policy, my lord. So on the date of accident, the insurance company doesn't stand as the insurer of that particular vehicle, my lord. So evidence.
So whether such plea was taken before
Yes,
the
yes.
tribunal?
Yes, my lord.
How the tribunal has dealt with the same?
Yes, my lord. Lordship, Lordship may kindly see page number 26. Paragraph 29.
Yes.
If the contract of insurance has been cancelled and all the concerned have been intimated thereabout, the insurance company would not be liable to satisfy the claim, but in this present case, from the evidence of DW1, it is evident that OP number 3 and 4, United India Insurance Limited had failed to bring on record. They had successfully delivered the intimation of the decision of check issued by the opposite party number 2 regarding cancellation of the policy to the insured. In fact, Lordship, notice was issued to them, and there is clear evidence. Lordship may kindly see again for that aspect, Lordship.
Whether the notice was
Yes, yes.
exhibited before the.
Yes, my lord. Yes, my lord. That is, Lordship will find at page 23, para 23. Page 22, paragraph 23. At the extreme bottom, my lord. Paragraph 23. Checks number so and so, dated so and so, drawn on the HDFC Bank as the premium check. However, the check was returned unpaid, and the same was informed to Surendra Kumar Roy by OP number 3 and 4 by letter dated 6/8/19. This was intimated, Lordship. Owner was intimated.
It appears that the trial court tribunal has relied upon a decision.
Yes, yes, my lord. Because that decision, my lord, relates to if the procedure is not adopted by the insurance company in intimation, my lord. But here in this case, intimation was made to the owner of the vehicle before the accident. Because the accident took place on 13/1/2020, and intimation was on 6/8/19, my lord. 6/8/19 in the address given by himself. That is the difference, my lord. Because Lordship, there is a provision under Insurance Act, Lordship, Section 64 BB. So that commencement of the risk is not there unless and until the premium is realized by the insurance company, my lord. In this case, no premium was realized. In fact, there was no contract for no consideration, my lord.
So whether you have cancelled the policy?
Yes. Policy is
No,
is
that is
cancelled.
what you have only delivered the information that the check was bounced.
Lordship, the content of the
As
letter.
per the evidence of DW1.
Yes.
But whether you have cancelled the policy?
Policy is to be cancelled, then only intimation will go, my lord. Policy is to be cancelled first, then intimation will go to the insured. I mean, the owner of the vehicle. Stating that
Whether that letter is available on the
not
record?
right now, not available to me.
You show me the letter.
Lordship, LCR will reveal everything, my lord. LCR will
Maybe,
call for.
but you have relied upon those documents. You produce the same. Otherwise, there shall not be any stay. Let it be on Wednesday.
My lord, maybe on Friday next, my lord.
Next Friday.
Next Friday.
Next Friday, that will be the last working.
27 last working day.
Because Lordship, maybe I will be out of station, my lord, till Wednesday.
Then after vacation.
Immediately on opening, my lord.
Okay. On the pair being made by Mr. Kohli, the learned counsel for the appellant, recessal is the method.
14th July.
But it may come after the vacation, my lord. I've taken consent from the appellant, my lord. Some difficulties I have to leave, my lord.
24.
24, my lord.
24.
VK Borwa.
VK Borwa with consent from the other side as for listing the matter after vacation. Parallel.
Highly obliged.
Item 6, the group DM, order matter 43.
My lord, my learned friend has given a chart that is not correct, my lord. The first is that, my lord, future prospect, as your lordship knows, if it is a fixed salary group, then it will be 40%, and they have added 50%. Then when the deceased is a bachelor, the personal expenses is 50%, they have taken 1/3. And thereafter, my lord, they have taken 40,000 into 5. Total dependent is 4. So there are a lot of mistakes, my lord. Your lordship, do one thing, let it come the next week. We shall give the fresh chart depicting the correct position of law.
And we have given our chart, my lord, as per the cities, my lord. So let them find us and your lordship will decide.
I think since there is a, my lord, differences, I think your lordship will like to hear it also.
That's okay, my lord.
All right.
Next week, any day convenient to your lordship.
Next week will be hearing day. No, sorry.
Motion day.
Motion day.
Then it will spill over to after the vacation only.
On Thursday, my small matter, they will give it by Monday, I think.
So I can give any day, my lord. No problem for me.
So Monday, Tuesday, my.
Let it be after vacation.
I think because your lordship will like to hear us also.
After vacation.
As agreed by learned advocates of both the parties, recessal is the method immediately after reopening of the vacation. As part heard.
Much obliged.
Standing item 39.
Mr. Dubey,
My lord.
there is a decision of Supreme Court.
My lord.
Revision petition, this petition under Article 227 is maintainable.
My lord is referring to manner.
Okay. But Mr. Dutta, even the,
My lord, I am not my lord, opposing this proposition. My lord, I am on different facts, my lords.
what fact?
My lord, this judgment says, my lords,
In the morning, you have submitted that it is
No,
not
no.
maintainable.
yes, because if it exceeds his jurisdiction, only 227 would lie.
Hmm.
My lord, my case is, my lord, it's a certiorari proceedings in which, my lord, 226 would lie. It's not a case where the 227 would be attracted. My lord, your lordship was pleased to entertain writ petitions. I am not submitting the copy. And in fact, these judgments, my lords, the 9-bench judgment of the apex court has also been considered. I was basing that, my lord.
Where?
But Lord, this judgment is, my lord, pursuant to, my lord, the election under the Election Commission of India, my lord. Lord, this is panchayat elections, my lords, where, my lord, your lordship has been pleased to, my lord, I am indicating to your lordship, my lord. I am relying upon 3 judgments. I'm bata raha hoon. Your lordship kindly have. Lord, first 2 are the judgment in which writ petitions have been.
No, we are not in respect of maintainability of the petition under Article 226. We are concerned with 227.
Lord, my submission is 227, Lord, the 3rd judgment which I am relying upon, which says that, Lord, in a very narrow campus it will lie, where the tribunal has exceeded its jurisdiction.
No, today is the motion day.
Yes, my lords.
So do we decide the entire matter today?
Lord, if your lordship may issue
Then-
notice, we can respond to it. Only thing, Lord, at this stage, my lord, no order is required is called for so far as interim is concerned, my lord. Lord, on 2-3 counts, my lords. First, my lord, we are also questioning the maintainability of the revision petition. Second, my lord, there is no record to show that the respondent has got or the petitioner has got higher vote than the respondent. Lord, that is still under the scope of, my lord, adjudication. And therefore, my lord, when the court below has issued a notice, my lord, it has not exceeded its jurisdiction. It has jurisdiction to decide election petition, and based on the materials, it only would call upon, my lord, in the other cases which I am referring, my lord, there was the question of counting of votes, my lords, recounting, which my learned friend has stated. My lord, that would only be done, my lord. The apex court has also said when the court is satisfied. Only at the first instance, court cannot be satisfied until and unless, my lord, the other parties have heard, my lord.
No, there was prayer for interim relief.
My lord.
That was not considered by the
My
tribunal.
lord. So, my lord, at least, my lord, it can be justified on the ground that, my lord, no, my lord, the ground has been made for seeking any interim relief, because still the respondent is an elected candidate, there is difference of 1 vote. But where 1 vote has gone, my lord, it's not that it is their case that it has been casted in their favor. They say there are anomalies. There could be anomalies that can be decided in election petition. But at this stage, my lord, it can't be ascertained that this vote goes to them. So, my lord, how on basis of these materials, my lord, this conclusion can be arrived at? The petitioner would be entitled to.
Mr. Dubey, I have already told you that we are not deciding the entire matter today.
No, I am on the interim, lord. If your lordship issue notice, my lord, we will file our objection and we, so far as maintainability is concerned. But I am on the interim prayer, my lord. Lord, they have not made out a case either before the election tribunal or before your lordships. They say there is anomaly of 1 vote. Lord, where is the material to show that 1 vote has been casted in their favor? Lord, there are other candidates also. At least RTI and the report, it says 137 and 136. They must have to prove and establish that they are getting more votes. And even 1 vote anomaly, either it may be in their favor or somebody else's favor. Lord. Even in the, it may be goes to the favor of the private respondent. So we cannot come to a conclusion at this stage, my lord, that 1 vote anomaly would clinch their case in their favor. So, my lord, I say that no, it's not a case of granting interim at this stage. And your lordship can keep the issue open as regards the maintainability.
Yes, Mr. Dutta.
My submission is that the rule says that if there are equality of votes, meaning thereby, if it appears that both the candidates have secured equal votes, then it has to be decided by toss. or by a lot. By a lot, that is what the rules say. Now, in the facts of the present case, my lord, when I have specifically made out on the basis of the materials supplied by them, that the counting of one vote remains shrouded in mystery. Why it was not counted? It is also not the fact, not a case that this vote was cancelled or this vote was declared invalid. The invalid votes have been indicated in the list, in the result sheet as well as in the RTA response. But the question remains that why this vote was not counted either in my favor or in their favor. But from the materials that have been placed, my lord, it becomes very much clear that the result which has been declared, that is not free from illegalities. That is not a clear mandate, my lords. Ultimately, the decision of the people, the mandate of the people has to be respected, and that is why, my lord, in a democratic process, the election is resorted to. He has secured one vote as per the calculation given by the respondents, my lord, but that does not become a clear mandate. And I have prima facie satisfied the court that there is anomaly in the calculation. And that was a case made out for recounting of votes, which was not done in my favor, my lord. That's why I had to approach the tribunal. Now, in a situation of this, my lord, will your lordships allow somebody to march past merely because of the fact that apparently his number...
Mr. Dotto, admittedly, the other party has secured one vote more than you.
Yes. Now, if the
equality,
if the uncounted vote is taken into account, my lord, then it becomes a case of 50-50 probability.
No, where is the material to show that that vote was casted in your favor?
No, that was, I do not say that it was cast in my favor.
Then
What I say is that since there was one vote remaining, it has to be ascertained in whose favor it was cast. If it was cast in my favor, my lord, then it becomes a case of equality of votes. I secured 136, the private party secured 137. Now, one vote has not been declared as to whether it was counted in favor of somebody or it was not counted. That is also not disclosed. Question is that, my lord, why the respondents are going in a hush-hush manner? What prevents them from declaring it on the day of the result, that this is the vote cast and this is the vote polled in favor of each of the candidates? In an election petition, my lord, prima facie, I have to establish that there is an anomaly in the process. And then only, my lord, the notice has to be issued, and notice has been issued. I am today on a different question. The question is that whether in the facts of the present case, the tribunal ought to have, Lord, had the tribunal considered my prayer and rejected my prayer, that would have been a different case. Here, my lord, if I just submit the rules, my lord, the rules say that the rules say that the tribunal deciding on the election petition shall have all the powers of the civil court, and these are enumerated in the rules itself. Now, in such a circumstance, I file, your lordship will kindly see the page 3 of this. Page 3, powers.
Yes,
Panchayat election tribunal shall, the lordship has got it.
Yes.
Panchayat election tribunals shall, for the purpose of disposal of the election petition mentioned herein before, shall have all the powers of a civil court. Now, in that circumstance, my lord, I file a petition before the tribunal asking for an order. Tribunals even does not refer to it in the order, whether it constitutes an error or not. That is the question before your lordship, my lord. If the tribunal considers it and gives a reason for rejection, my lord, things could have been different. It could have been seen from a different angles. Tribunal simply does not recognize the prayer. And I have enclosed the election petition with the brief of the civil division petition itself, my lord. Your lordship will kindly see the prayer that I have made here, page 30, and the prayer made is at page 36. It has to be, the whatever, whoever be the winner, my lord, he has to come through a democratic process, fair democratic process. And prima facie, my lord, there are materials in the case to suggest that the process has not been fair. Page 36, my lord, my prayer is there.
Yes, Mr. Dubey, can you obtain instruction of why this vote was, single vote was not counted?
My lord, that will respond to. My lord, will kindly have a look, my lord, the judgment I am referring to for a moment. I'll, my lord, answer all the queries posed by your lordship. My lord, this is Manju Begum, my lord. The first para says, my lord, the instant writ petition under Article 227 of the Constitution has been instituted by the writ petitioner seeking a writ in the nature of certiorari for setting aside and passing on an order passed by the district judge Nalbari in the capacity of panchayat election. That was regarding, my lord, counting of votes, which a prayer made by the petitioner herein also. Now, your lordship kindly refer to para 16. Has your lordship got, my lord?
Yes.
The law regarding counting of votes is well settled. It has been constantly been held that recount of votes could be ordered very rarely, as secrecy of ballots has always been considered sacrosanct in a democratic process of election. It is not to be disturbed lightly on bare allegation of illegality or irregularity. It is only when it is proved that sanctity of election has been tarnished and it has materially affected the result of an election whereby the defeated candidate has been seriously prejudiced, the court can resort to the process of recounting of votes to do justice between the parties. It has been held by the Honorable Supreme Court of India in Uday Chand versus Surat Singh and another reported in so and so to the effect that before an election tribunal can permit scrutiny of ballot papers, an order of recount, two basic requirements which the election petition seeking recount of the ballot papers. So, my lord, what your lordship has says regarding one vote, still we have to answer. My lord, the election petition was filed on 16th. It was moved on 18th. Today is 20th. My lord, in all the cases, my lord, the notices has to go. They will respond, my lord. It's not that immediately I can answer to your lordship's query. Why it's been not as of date, as of now, my lord, it's been held that the respondent has got 137. Petitioner has got 136. My senior friend has said that when equality, my lord, where is the equality, my lord? As of date,
No,
you may allege allegations, my lord.
No, Mr. Dubey, you say, while the petition was filed before the tribunal,
My lord.
the tribunal has not considered the pair at all.
Lord, they had tribunal has issued notice. My lord, that's why I'm saying.
No, they're interim pair.
My lord, it will, my lord, in a matter of course, it can't be an interim prayer, my lord. Though there are no results, my lord, I have a right to justify the order passed by the tribunal. On the sense, my lords, that your lordship has seen. This anomaly would only be rectified if the recounting of vote is ordered. Your lordship has seen what the apex court says. The apex court says that it's not a matter of course. There has to be pleadings, justification. Then also, what my submission is, my lord.
No, Mr. Dubey, if that is the position, then the court would have rejected. The tribunal would
Lord,
have
issuing,
rejected.
issuing of notice and not granting amounts to. Therefore, my learned friend is over here, my lord. Otherwise, why you would have been here? The fact that only notice has been issued, no interim prayer has been granted, my lord. That's why being aggrieved, they have been before your lordship. Now your lordship has been called upon to say that my learned friend has says inequality rule will count. Because where is the equality? Even without counting or recounting, we cannot come to that conclusion, my lord. So my submission is, my lord, what essentially is being asked for is a recounting where these things would come into play, and that can only be done after the other party is heard and a case is made out, not at the very first instance, my lord, when the case is filed. And the apex court has also said. And therefore, my lord, when the tribunal has not acted beyond its jurisdiction, 227 will not come into play, my lord. Had it been a case it was not entitled to pass any order, then only they could have come under 226. I'm not saying in part.
When the petition is filed before the tribunal, tribunal is not entitled to pass any order.
They have issued a notice, had not granted any interim order.
So why the order is silent regarding the interim pair?
Look, that automatically would not entitle them to an interim order. That's why they are before your lordships. Now your lordship has to consider this aspect. So for a moment, assuming this 227 is maintainable, now I call upon your lordships that on what basis it could be said that, Lord, as of date, until unless it is quashed, certiorari is issued, that election is declared null and void based on the counting. How can it be presumed, my lord, that he has got either equal vote or more vote? And in other count also, my lord, he cannot go out, get more than the respondent, my lord.
No, in respect of regarding the pair made by the petitioner before the tribunal, this interim pair.
My lord.
So the interim order is silent.
No, it's silent, that means refused. There could be good reason, bad reason, no reason. Now your lord, if your lordship is examining that, only bad fact that the tribunal has not granted any interim order, then also they have to establish a case before your lordships that I am entitled for an interim order based on these facts. My learned friend says two things. My lord, equality first, which has not been displayed. Second, my lord, it could go either way, that way. The moment he says that it could go either way, my lord, he has not made a case for your lordship's interference. We are still presuming. As a writ court or 227 court, my lord, no order can be passed on presumptions, my lords, when the facts are very clear until they are dislodged.
My lord, my case before this honorable court is not on the question of counting or recounting at this stage.
That result will come on the basis of
My
that.
question, my case before this honorable court is whether by not recording my prayer, not considering the prayer for interim relief, the tribunal has acted without jurisdiction or not. That is the question. Whether the tribunal, having not considered the prayer for interim relief, having not even rejecting it by an express order, not even accepting it by some order, whether it has constituted an error which warrants your lordship's interference. But one judgment I will just place before your lordship, my lord, and your lordship knows, my lord, that 227, your lordship can exercise the jurisdiction, supervisory jurisdiction, if there is an error of jurisdiction by the inferior courts or tribunals. But one judgment, my lord, there is a decision, my lord, I have cited 2006 10 SCC. The lordship can kindly come to page 63. Reliance Airport Developers. Page 63, paragraph 102. And on the next page, page 64, my lord, it starts from a summary can therefore only state the, has your lordship got it, my lord?
Paragraph number?
Page 64, it is continuation of paragraph 102.
Yes.
A summary can therefore only state the long established rules together with the simpler and broader rules, which have now superseded them, much for the benefit of the law. Together they are as follows. Now, errors of fact, my lord, we are not concerned at this stage. Errors of law. Old rule, the court would quash only if the error was jurisdictional and on the face of the record. New rule, the court will quash for any decisive error because all errors of law are now jurisdictional. So here is a case, my lord, it was a jurisdiction vested. It is a jurisdiction vested in the tribunal to decide the case, which the tribunal has not exercised in the matter. And therefore, a jurisdictional error arises. A case for jurisdictional error arises. Well, there are other judgments, including your lordship's judgment, when 227 jurisdiction can be resorted to.
Okay, not necessary.
So, my lord, the primary objective is to keep the inferior tribunals and courts within the bounds of their legal limits. And if there is a violation of the principles in regard to exercise of jurisdiction, some jurisdiction vested in it, but it has not exercised in a lawful manner, your lordships will interfere. So therefore, today, my lord, I am on a very limited question that whether on this count, it can be construed to be a jurisdictional error or not. Whether recounting is necessitated or not, that will be determined in the tribunal, my lord, after taking of evidence, after receipt of response from the parties and taking of evidence. But prima facie on the day of motion, my lord, it was incumbent upon the tribunal to at least focus on this aspect of the matter. And apparently, my lord, as the materials on record show, my lord, apparently it is clear that the declaration of result in favor of respondent number 5 has not been through a fair process. There, the process is faulty. And it cannot be, he cannot therefore claim to have the mandate of the people to take oath as an elected member, as an elected member.
Okay. Mr. Dubey, This judgment you have referred is based on the decision of Supreme Court in Udasan versus Surat Singh.
My lord,
What is the judgment before the court?
I'll do, my lord.
We'll pass the order.
My lord. Only one line can, if your honor lordship permit, can I add one more? Lord, if your lordship see the prayer which has been made in the election petition is for cancellation and recounting. Lord, based on the materials placed by, it's only when the materials from the other side comes, Lord, then only your lordship decide or the tribunal decide whether it's a fit case for or not. As of now, my lord, the material is there only by what has been placed by the election petitioner. And my lord, it also says that 137, 136 in both in the result as well as in RTI. So on basis of that, the court tribunal could not have come to any conclusion which would have supported their case, my lords.
Okay,
I'll place that judgment before your lordship.
We'll pass the order.
Now, my submission is that Miller, till the thing is finalized, Miller, at least status quo as on date should be maintained. Tomorrow is the date for taking oath, Miller. Nothing has
Pass
crystallized.
the order today.
Yes.
I'll furnish that judgment.
Pending item 40.
My lord, page number 54. The name of the witness, lordship. 54. This was my petition, my lord. Last line, paragraph number 3. Granted for evidence of the official witness, Circle Officer, Dolgao Revenue Circle. And the order is at page number 59, my lord. For a moment, my lord. 59, paragraph 4. Official witness Himanshu Kashyap, is the Circle Officer, has appeared today. However, none from the defendant side is present to examine him. So we are absent, my lord. That is why discharge, but the cost is deposited, my lord.
You see, this order was passed on 24th of January 2025.
Hi, my lord.
You have been discharged from the hospital on 11/11/2024.
11/11 discharge, but thereafter I was detained due to my operation, my lord.
Oh,
Neurological.
Where is the document to show that you have been bedridden
lord.
at that during that
Yes.
point of time?
Lordship, page number 48 is the discharge certificate, my lord. And page number 48 onwards are the documents, my lord. 48, my lord. Thereafter page number 8.
No, these
50 may be
documents are
seen, my
there.
lord.
This
Page
this
number
certificate
50.
is there.
After operation, my lord. Page number 50, my lord. These documents were issued on 11 December 2024, and he visited again, my lord. My lord, lastly, page number 52, my lord. Totally bedridden, my lord. 52. This was 15 to 2025 in the month of February, my lord. So, my lord.
No, where it is written that the patient was totally bedridden?
My lord, it is written. My lord, page number 53, when he was under treatment, my lord, his wife submitted this application, paragraph number 2.
There simply stated that severe illness.
Severe illness, now under medical treatment at GMCH at Engage, yes, my lord, Engage Counsel. So, my lord, the severe illness, my lord, operation was not written, but medical document says there was
There is
operation.
no
my lord.
dispute regarding operation. But the question is after the operation, whether he was bedridden.
My lord,
Till
doctor
the
says.
impugn order on 24/1/2025 was passed.
My lord, doctor says, my lord, of surgery, my lord. That documents is there, my lord.
Who is document?
My lord, page 45, my lord. 45. It's a advice column, my lord. in
That
the
is
middle
already
portion.
there.
My lord, refer. Right hand side, my lord. My lord, neurosurgery, my lord. So, for head injury. My lord, page number last, if your lordship kindly see, the last medical documents was in the month of February 2025. So, my lord, our only simple and humble prayer is that
Where
only
is the-
witness,
Where is that document?
my lord.
February 2025?
My lord, page 52, my lord. Page 52.
Is there any reference to the fact that he was bedridden at a relevant point of time?
My lord, this is the language of doctor, my lord. I think
Which one?
care of my CO is written here, my lord. Some head DOE labor limits. My lord, actually, these are the
No, I am
critical
asking you
condition.
whether it has been mentioned that you were bedridden at that point of time.
My lord, since number one FIR says head operation, doctor says my lord neurological surgery. So my lord, the document says my lord, till February 2025, he
No,
was under
You
treatment.
do one thing, you produce any document to show that at a relevant point of time you were bedridden.
My lord, my first application was my lord. My first application was page number 53. This was simply says severe illness. Thereafter, in my review application, my lord, in my review application, page 60, my lord.
No, you have mentioned
60,
in your
page number-
petition and in your review petition also, but where is the medical document to support it?
Medical documents.
Your
my lord,
pair was rejected by this court, by that court, trial court.
my lord.
And to consider the same by this court, you have to substantiate it. But where is the document to substantiate your pair?
My lord, number one documents, my lord, learned trial court observed that my FIR last paragraph, as your lordship has seen, that there are some brain, my lord, head operation.
List
Now-
Wednesday, so as to enable the learned counsel for the petitioner to produce any document in support of his contention that from the date of his release, or date of his discharge from the hospital, that is 11/11/2024, till the date of passing of the impugn order, dated 24/1/2025, he was bedridden.
25th June. Admission matter, item number
Coverage. May I please, your lordship?
Lordship, I'm from restaurant number 1. Lordship, we need to engage a senior advocate, Lordship. Kindly give some time, Lordship.
No, we are yet to admit the matter. We are yet to issue notice. Mr. Dotto, this is a death case or injury?
Well, injury case, my lord. What happened? There are 3 vehicles involved.
Pardon?
3 vehicles involved. The petitioner, my lord, sorry, the claimant, and another vehicle got involved in accident. The other person who got involved in accident died. The claimant got injured. In the meanwhile, the vehicle which was insured with our company, it also came in and dashed with this vehicle. This fallen vehicles. Now the entire liability has been settled on the company, the vehicle which I'm representing, I mean which is insured with us. Now the the claimant denied that there was involved in 3 vehicles. But one of the PW3 clearly stated that initial accident happened between the bullet and the bike of the claimant, where the bullet rider died. And the claimant also got injured. Now the entire liability, however, has been settled on us. PW3 is very specific, and that has been discussed also in the evidence.
Mr. Dotto, let notice go. Let the record count.
Yes, I'm praying for a stay of the judgment.
Deposit 50%.
Yes.
Heard, Mr. Dotto, learned counsel for the appellant, and also heard Miss
N.A. Begum, your
NK,
N.A. Begum.
learned counsel for the respondent number
1, Lord.
Respondent number 1. This appeal under section 173 of the NBA is directed against the judgment and order dated 17/2/2025, hospital learned number, motor accident claim tribunal, Kamrup M number 2, in MSC case number 2079 of 2021. file under section 166 of the IPS. It is to be noted here that by the impugn order dated so and so, the learned tribunal has directed the appellant insurance company to pay a sum of rupees 17 lakhs. Is it correct, Mr. Dutta?
Yes, madam, 17 lakhs.
23,360.50. Being the compensation to the respondent number one.
One.
Respondent number one. Peruse the memo of appeal from the grounds mentioned therein.
Pardon, madam?
Also peruse the impugn judgment and order award dated 17/2/2025. Admit, issue notice to the respondent. Returnable in forex, the plea taken by registered post with AD and also by usual process within our. However, no formal notice is required to be issued to the respondent number one since Miss so and so entered appearance and received notice. However, extra requisite copy of the petition be furnished to her during the course of the day. Less than the after forex. It's higher of 50% within 4 weeks from today.
Madam. Obliged.
Caveat would be hard. Caveat distance research.
Yes. Obliged.
Hearing, item 12.
Wait, please, is your lordship, madam. Madam, this is a. In fact, earlier occasion, your lordship.
Sir has been framed here.
No,
Trial court.
no, my lord. My lord, I am basically on this Rehan Kumar and Pradeep.
We have
Gupta, my lord.
Kumar.
Because my lord, I have the occasion to gone through a few judgments of your lordship, my lord, where your lordship has held that the communication of the ground of arrest are mandatory.
But you have to establish that it was not communicated to you.
Absolutely, my lord, I'll demonstrate.
Where is the document?
Absolutely, my lord. My lord, may kindly come to the FIR first, my lord.
No, forget about FIR. You show me that the grounds of arrest are not communicated to you at the time of arrest.
My lord, at the time of arrest, what they have communicated me is at page number 38. They have communicated a wrong ground of arrest, my lord.
No.
Ah.
Grounds communicated or not?
My lord, the grounds which have been communicated does not attribute.
But you see, this wrong ground or right ground that can be adjudicated in this petition.
Yes, my lord, because there is a order of your lordship. I'll show that the ground of arrest which they have mentioned in page number 38, they are contradicting the order passed by this honorable court. I'll demonstrate that prima facie. I'll show it, my lord. My lord will see what are the grounds of arrest which has been given here, page number 38. The arrested accused person or the FIR. This is common, my lord. I'll come to B later. I'll first say A, C, and D. A, C, and D, these are common grounds of arrest, my lord. These are what Supreme Court says. These may be reason, but grounds of arrest has to be specific to the person, what role he has played in the offense. Now, B, my lord. During the course of investigation, total one number of shop case containing powdery substance suspected to be heroin, weighing 11 gram, and also 10,000 yaba tablets have been recovered and seized from the possession of the arrested accused person in presence of available witnesses. So, my lord, if I understand this correctly, then 11 grams of heroin and 10,000 yaba tablets were recovered from my possession. That is, and therefore that is a specific ground of arrest, and I have been arrested. Kindly come to your lordship's order at page number. My lord may come to page number 36. Because on an earlier occasion, your lordship has perused the records, and at para number 7, this is the finding of this honorable court. I'll go by the findings of the court, my lord, rather than what police have written. Perusal of the case diary reveals
that the IO has collected sufficient incriminating materials against the present accused. The next line. It is a fact that no contraband substance were recovered from the possession of the present accused as per the seizure list, that is Annexure 3 and 4. But from the material collected so far in the case diary, it is apparent that he accompanied one Akmal Hussain for selling drugs at the Central Guest House on payment of 5,000. My lord, your lordship's finding is based on the seizure list, which your lordship will find at page number 25. The case record as well as the seizure list. Page 25, my lord will kindly see. This ground of arrest, this arrest memo is a psycho style, my lord. They have copy paste for all the accused person. Exactly with grammar preposition same. Page 25, my lord will see. This is the recovery of commercial quantity of Yaba tablets of 10,000 gram. 10,000, tablets. Page 25. Page 25 is the type copy. Page 26 is the original. The handwritten. It is recovered from one Hasumia and Amina Khatun. Nothing was, it was not recovered from the present petitioner. And your lordship's finding at page number 36 that he has accompanied one Akmal Hussain. Akmal Hussain is attributed with only 11 gram of heroin, which is intermediate quantity. Because there are 4 persons. This page number 25, Hasumia and Anim. Yes, my lord.
The submission you have advanced today,
Yes, my lord.
that has to be adjudicated during the course of trial.
So what I'm saying, my lord, is that ground.
Now the question before this court is whether the ground of arrest was communicated to you or not in compliance with the decision of Supreme
Absolutely.
Court in the case of Bihan Kumar or not.
Absolutely. Now, my lord, if they communicate, because communication of the ground of arrest was Vehan Kumar says is not a formality. It is not a formality. It has to be specific to that. Now, suppose, my lord, communication of a wrong ground amounts to nullity. If I communicate a ground which can never be attributed to me, it amounts to communication of no ground. Because, my lord, in that case, they may write whatever they want. If it is based on, I cannot dispute the material at the stage of bail. If there is some material.
You tell me whether 10,000 Yaba tablet was recovered in this case or not.
In this case from somebody else.
No, maybe I am asking you
Yes.
whether it was recovered in connection with this case or not.
This case.
Recovered. Yes. The 11 gram heroin was recovered from Akram, with whom you were present.
My lord,
Right.
with Akram, with whom I am present, as if I go by para 7 of page 36, yes.
You have accompanied Mr. Akram from whose possession 11 gram of heroin was recovered.
As per the police, that is what the police is building up. That is what the police is building. My lord, what I am simply saying.
Can it be said that you have not communicated the ground of arrest?
My lord, what I am saying, my lord, in fact, in para number 7 is the answer of your lordship's observation, page 36. My lord will kindly see what is the ground of arrest for the present petitioner ought to have been. The ground of arrest of the present petitioner ought to have been that you are arrested because you have accompanied one Akram who has that is the correct, that ought to have been the correct ground of arrest, because the very purpose of communicating the ground of arrest is to give me.
You tell me recovery of 11 gram of heroin and 10,000 Yaba tablet were done in same transaction.
Was done in same transaction. It was done in same transaction, my lord. Separate recovery transaction means, my lord, I am not getting your lordship from the same place your lordship is asking me.
No, in the same course of action.
Well, I mean, it was recovered on the same day.
Yes.
Yes. My lord, my limited point here is this.
So you tell me whether this section 29 will not be attracted here.
My lord, section 20, my lord, I cannot argue on section.
For recovery of this 10,000 Yaba tablet.
My
For
lord,
recovery of 11 gram of heroin with Akram. with whom you were present?
My lord, section 20, my lord, section 29, they will have to establish that whether there was a concert, union of mind, whether there was a consensus, my lord, all this, what I am simply arguing is this, my lord, that this ground of arrest, my lord will see what the Supreme Court says, my lord. Because they are doing my lord will kindly come to page 39, page number 38, that is the ground of arrest communicated. My lord, if this is how police communicate, then they will write anything against anyone, my lord. Page 38, my lord have seen, though it is not recovered from him, but they are saying, during the course of investigation, total one swap case containing powdery substance suspected to be heroin weighing such as recovered and seized from the possession, my lord. There is no question of section 29. It is direct possession. My lord will just turn to page 39 and we'll see whether there is one grammatical change or not. This is copy paste. It is from page number 39, this Hasumia, from whom this was recovered. Same copy paste, not even a tense.
No, that is the subject matter of adjudication during the course of trial. Anyway, what is your submission?
Yes, my lord, your lordship, here in this case, my lord, while after rejecting of this two bail application, why he has approached before this honorable court today? Because at that point of time, it was not pointed out before this honorable court that grounds of arrest were not communicated to the petitioner. But admittedly, from the, my lord, notice and everything document attached herein, my lord, it is very clear that grounds of arrest were communicated to the petitioner. Whether those grounds were wrong, whether those grounds were right, my lord, can this honorable court, my lord, adjudicated in this bail petition, my lord? And regarding, my lord, while starting his argument, initially he started by saying that I will point out some of the arguments of your lordship, whereby your lordship has stated regarding specific role played by the petitioner while furnishing the grounds of. Where is that judgment, my lord? While starting his argument today itself,
I have not even completed.
he has, my lord, stated that there is some specific role played by the petitioner regarding that aspect, my lord. Some judgments pronounced by your lordship, my lord. So, my lord,
I am not being.
Here it is very specifically clear, my lord. It is very clear from the notice, my lord, that those grounds were communicated, and in presence of the present accused, those 10,000 Yaba tablets, there 11 grams of, my lord, heroines were recovered, my lord, and those grounds were specifically mentioned in the, my lord, grounds of arrest. So, my lord, where is the question of, my lord, again adjudicating on those points, my lord?
My lord, I am
bail petition, my lord.
My lord,
this is not a fit case for granting bail.
My lord, I am convinced that neither he has read my petition nor he has read the case diary.
I have read
because he is saying that the seizure was made in my presence. My lord, to whatever little.
Mr. Biswas will examine the matter. We will see whether the ground of arrest mentioned in serial number 2 constitute the word communicate, which has been discussed in the case of Ihan Kumar or not.
And regarding that aspect, my lord, I would like to point out one judgment.
If your lordship may take it up in some other, my lord, if your lordship wants some here, because my lord, I'll have to indicate something. If suppose in case there are other matters, my lord, your lordship may fix it in some other days, my lord. I'll argue because there are certain things I want to indicate, my lord, at least, my lord.
What?
My lord, because my lord, what he is saying that it was recovered in my presence. My lord, to whatever little criminal investigation I understand, if it is recovered from my presence, my signature would be there in the seizure list. Or what? My lord, either he'll argue or I'll argue.
No, you can.
My lord, my signature would be there in the making a submission from a thin air from where I come. I am
not necessary to.
But my lord, my lord, I'll have to rely on these two judgments, my lord.
Okay, I will say whether this ground will satisfy the requirement of Ihan Kumar or not.
My lord, because the specific paragraphs which I am relying on,
I have seen it. I have seen it in your decision. You have submitted before this court. You have marked it.
Sir, the specific paragraphs, my lord.
Yes, I have seen it. In this decision, you have marked it.
Marked for us.
You say this.
Well, then your lordship will just, my lord, I'll just say the paragraphs.
These are the paragraphs.
My lord, I'm not. I'll just say the paragraph numbers, my lord.
You can see it. Okay. I heard Mr. M. Biswas, learned counsel for the petitioner, and Mr. E. Bordhapur, learned additional PP for the state. Have you been concluded order is it?
Well, the paragraph numbers, I'll give it to the court master, my lord.
Yes, you can.
Just for hearing under order.
Because which says that it should not be a formality just for the.
Yes, yes.
No, I'm,
13,
there are 20.
13.
I'm giving one of the judgment, madam.
May I please, my lord? My lord, in this case, I have filed the amended appeal memo, my lord. My lord, this is a flag A, my lord. My lord, this is a regular second appeal against the, my lord, judgment of reversal, my lord. Appellant paper or lordship is, my lord, defendant. My lord, suit was dismissed, counterclaim was partly allowed. My lord, substantial question of law is at page 3, my lord.
So whether any issue was framed on the point of limitation?
Yes, my lord. My lord, point of limitation, both for the suit as well as for the counterclaim. And my lord, the trial court has decided that both suit as well as the counterclaim is not time barred. Whereas my lord, appellate court has held that the counterclaim was barred by limitation, my lord. That finding lordship will find the appellate court, my lord, that is at page 93, my lord. Page 93. B, my lord, in the bottom part, my lord, issue B, number B, whether the counterclaim is barred by limitation. The learned trial court observed that the counterclaim of the defendant is not barred as the defendant has made his counterclaim within the statutory period. Moreover, the limitation for defendant's claim started when the plaintiff brought the suit against them and accordingly decided this issue in favor of the defendant. This appellate court and perusing of the WS and the counterclaim in specific found that the basis of defendant's prayer regarding declaration of his right title interest over the suit land and confirmation of possession thereon is solely based on Exhibit Co. The agreement for sale dated 23/12/2000 allegedly executed by the plaintiff number 1 in his favor in respect of the suit land. On perusing Exhibit Co. The agreement for sale, it is found that there is no specific recitation as to when the executant is required to execute the registered sale deed on the basis of the same. In general, the rule is that the agreement for sale itself specifies the timeline for execution of the sale deed in respect of the concerned property. However, when the said documents is silent regarding the limitation for performance, the limitation for a specific performance of the agreement for sale may start when the buyers come to notice of the seller's refusal to perform. Article 54 of the Limitation Act prescribes 3 years time limit for filing the suit for a specific performance of contract from the date of notice of refusal. In the instant case in hand, it is very much clearly seen that the defendant number 1, until filing of the instant suit in the year 2017, never come up with any such plea for a specific performance of contract. And as such, Exhibit A becomes automatically legally enforceable on expiry of 3 years from 23/12/2000. Thus, it is seen that the counterclaim of the defendant number 1 is barred by limitation. My lord, may
So what section 53A states?
my lord?
53A of transfer of property.
My lord, it says, my lord, that if any agreement is there and pursuant to an agreement, possession is given, and then, my lord, if no, section 53 of that. Basically, it says, my lord, even without the registration of the agreement, he can retain the possession, my lord. That is part performance of the contract.
Whether this substantial suggested substantial question number 2
My lord.
is whether the learned first appellate court is right in deciding issue number C,
Yes, ma'am.
which is neither framed by the learned trial court nor during the appeal.
Yes, ma'am.
Whether any question of law was formulated by the
My lord, what happened?
point for determination was formulated by the appellate court.
No, my lord, appellate court has not framed any issues, my lord. Or,
Yes.
but what happened, my lord, the trial court has framed, if lordship may kindly come to page 39, my lord, issues framed by the trial court, my lord. Page 39, that is the relevant portion of the trial court judgment. Relevant will be, my lord, page 40. Issue, my lord, issue on counterclaim C, my lord. Whether the plaintiff number 1 delivered the possession of the suit land to defendant number 1 for consideration amount of rupees 10,000. This is the issue framed by trial court. Now, lordship may kindly turn to, my lord, page number 95, my lord. What trial court has decided, my lord? Page 95. Issue number C. Whether the plaintiff number 1 executed an agreement for sale with defendant number 1 in respect of suit land for consideration of rupees 10,000. The learned trial court did not decide this issue while pronouncing the judgment. My lord, this is nobody case, my lord. Even the trial court has not framed this. Even the defendant has not asked for a specific performance of the contract, my lord. He has said that, my lord, since there is agreement, pursuant to agreement, he has given the money and the possession was given to him. But no subsequently sale deed was registered, but he is possessing the land, my lord. So that's why he says that, my lord, his case is that since he is possessing the land from the 2000, so he has claimed on the basis of adverse possession, my lord. The trial court has said that since he is not able to prove the adverse possession, but since there is part performance of the contract, therefore under section 53A of the Transfer of Property Act, he is entitled to retain the possession of the suit land, my lord. Only that much relief was granted, but the appellate court, my lord, issue number C, which is neither framed during the trial nor by the appellate court, my lord.
No. The appellate court, being the first appellate court, whether not entitled to frame any point for
No,
determining.
my lord, appellate court has ample power to frame the issues, but that has to be framed during the, my lord, before the writing the judgment, my lord. And my lord, one opportunity is to be given because order 4125 says that, my lord, if the appellate court frames any issue, then that may be then send it back to the trial court or to other court to give both the parties opportunity, my lord. Because this is nobody's case, my lord. So it is not framed during the pendency of the appeal. While writing the judgment, that the appellate court has, my lord, due to mistake or something, because the appellate court says, my lord, this issue was not decided by the trial court. Whereas this appellate court says, my lord, this issue was not decided by the trial court. Whereas trial court has not framed this issue, my lord. If lordship may come to, my lord, page 30, compare, my lord, page 40 and 95. The issues are totally different, man. And my lord,
Oh, wording may be different, but the substance is same.
no, my lord, the trial court says, my lord, that the trial court issue number C is whether plaintiff number one delivered the possession of the suit land to defendant number one for consideration amount of rupees 10,000. Whereas, my lord, appellate court has decided the issue that whether the plaintiff number one executed an agreement for sale with the defendant number one in respect of suit land for consideration amount of rupees 10,000. But the totally, my lord, different facts, my lord, because here it is with regard to execution of the agreement, my lord. And the trial court has decided with regard to, my lord, the delivery of possession, my lord.
We'll see. But Mr. Gupta, learned counsel for the appellate. Order is that
Okay.
File number 14.
Well, please, your lordship. But I would like to seek an adjournment on the matter today, because some new facts have come to light. We would like to, incorporate that in additional validity.
on the pair being made by Mr. Iketas, learned counsel for the appellant. The matter stands over for the day.
15.
My lord, page 7, the substantial questions are there. Page 7.
So these questions are not part of memo of appeal.
I have in page number 7, my lord.
Page number 7 is there. But you have not mentioned in the memo of appeal. You see subsection 3 to section 100. But Mr. Sohan, learned counsel for the appellant. This is the matter immediately after reopening of the vacation, so as to enable Mr. Sohan to file amended cause title, complying the subsection 3 to section 100 of the CPC.
Item 42.
Wait, please, your lordships. Last occasion. Lordship had asked me to frame, draft an additional substantial question of law, my lord. I have got it. I'd also like to place a judgment, my lord, on the fact what happens when there is no specific denial of a plea in a written statement. It's a recent judgment of 2024, my lord. May I just hand it over? This is the substantial question of law which I have framed, my lord. The lordship takes up page 253 of the judgment, my lord, para 23.
The perusal of the plaint filed by the respondent shows that it contains 10 paragraphs besides the prayer. In the written statement filed by the appellants, no specific para-wise reply was given. It was the own story of the respondent containing 15 paragraphs besides the prayer in para 16. In the absence of para-wise reply to the plaint, it becomes a roving inquiry for the court to find out as to which line in some paragraph in the plaint is either admitted or denied in the written statement filed, as there is no specific admission or denial with reference to the allegations in different paragraphs. Order 8 Rules 3 and 5 CPC clearly provides for specific admission and denial of the pleadings in the plaint. A general or evasive denial is not treated as sufficient. Proviso to Order 8 Rule 5 CPC provides that even the admitted facts may not be treated to be admitted. Still, in its discretion, the court may require those facts to be proved. This is an exception to the general rule. General rule is that the facts admitted are not required to be proved. The requirements of Order 8 Rules 3 and 5 CPC are specific admission and denial of the pleadings in the plaint. The same would necessarily mean dealing with the allegations in the plaint para-wise. In the absence thereof, the respondent can always try to read one line from one paragraph and another from different paragraph in the written statement to make out his case of denial of the allegations in the plaint, resulting in utter confusion.
And now you have suggested only one.
Only one month
Only
on
one.
that point. It was in fact there in 5, but changed the wordings because the provisions of Order 8 Rules 3 and 5 were not incorporated.
But in the learned counsel for the appellant, this second appeal under section 100 of the CPC is directed against the judgment and
12/8/2024.
against the judgment and decree dated 1/2024 passed by the learned civil judge Borbetta in title appeal number 6 of 2024. It is to be noted here that by the judgment and decree dated so and so, the learned first appellate on the learned civil judge Borbetta has dismissed the appeal filed by the appellant challenging the judgment dated 8/1/2024 passed by the learned civil judge Junior Division number 1 Borbetta in PS number 370 of 2014, whereby suit of the appellant struck plaintiff was dismissed. First, the memo of appellant grounds mentioned therein and also the suggested substantial question of law. This appeal is admitted on the following substantial question of law. Either the learned courts below are justified in denying the pair of the appellant struck plaintiff for eviction of the respondent struck defendant from the suit land, while the respondent struck defendant had not specifically denied in their written statement the allegation made in paragraph number 11 of the plaint regarding trespass made by the defendant. In view of the specific provision of Order 8 Rule 3 and 5(1) of the Code of Civil Procedure. Then hereby admitted the allegation of the appellant plaintiff. Issue notice to the respondents, returnable and for which the be taken by research also AD and also by its process within report today. Research shall call for the record from the learned courts below. Please the matter after for which.
Item 16, matter for orders.
Please, the lawsuit. Lordship, this regular first appeal against an ex parte judgment and decree. So this was there was a title suit, but money decree has been passed awarding 15 lakhs of rupees as well as 15 lakhs of rupees as a cost and 20 lakhs of rupees as compensation. That money decree has been passed. That is an ex parte decree. I am not on the merit of this case today, itself, Your Lordship. Appeal has been admitted, record has been called for. In the meanwhile, what happened, Your Lordship, their execution proceeding was started by the judgment or the decree holder respondent side. So there was an immediately what happened, Lordship, the execution proceeding is there. So we filed an application before the learned trial court, executing court, saying that the appeal has already been admitted, the record has been called for. So the learned trial court rejected our application. That is Miss Case Lordship, IS Civil Lordship 1816. Lordship, at Annexure 1, page 10, that petition we have prepared before the learned executing court, stating that the regarding admission of the appeal, regarding call for the records. But the learned executing court, Your Lordship, via Annexure 2, order dated 14/5/2025, rejected our application and directed the decree holder to take steps for the as per decree. So, Lordship, the record has been called for. We are ready for hearing. The matter may be come up at the immediately after vacation. We are ready to take final hearing. In the meanwhile, Lordship, if the decree is executed, then my entire appeal will be infructuous. Regarding
No, Mr. Yeah,
Lordship,
you see, money decree was passed.
money decree was passed, admittedly.
So in order to stay the money decree, you have to deposit the security.
Secret, we have Lordship, we have give the Lordship bond. We are ready to execute a bond.
No,
Lordship,
whether execution of bond will be sufficient.
definitely sufficient, Lordship. Definitely will assure the Lordship that we will, in the event of failure of the decree, failure of the appeal, we are ready to pay the amount. Because it is an ex parte decree, Lordship.
No,
I am not on the merit of the appeal, Lordship, today. And
But
matter will be
the,
heard, Your Lordship, immediately after vacation.
What is the amount? Decretal amount?
35 lakhs.
No, unless you deposit security, we will not be able to stay the proceeding, execution proceeding.
So we are ready for final hearing. Only 1 month time is required. Only after vacation, Lordship, immediately not 1 month. Security.
Earlier, in one case, one of the coordinate bench of this court has stayed the money decree without security, but Supreme Court has come down heavily. So if you agreeable to pay the 50% of the decretal amount before the registry of this court, then all right.
Lordship 25%, because as on date, what happened, Lordship? What happened? But so far, the appeal is concerned is not in a position.
My lord, in that case, may I pray that we may be allowed to file an objection against the same, because the application was only received yesterday. And the execution which the appellants are contemplating, with regard to that, I would just state that we are also not aware of what assets they have. We have filed an application before the executing court merely asking the appellants to disclose what assets they have in their possession. Prior to obtaining that information, execution cannot in any case proceed.
Lordship, then
Otherwise, we may finally
Lordship,
hear the matter.
Lordship, immediately after vacation, Your Lordship.
In I take down a hard Mr. Okay, we are learned counsel for the applicant. And also hard Mr.
And children.
Learned counsel for the opposite party. This interlocutory application is preferred under section 151 of the Code of Civil Procedure. For staying further proceeding of title execution case number 15 of 2022. The learned counsel for the opposite party submits that he may be granted some time to file objection. That is accordingly allowed. SSL is the matter immediately after reopening of the petition.
July 17.
In part A, you take down hard Mr. Bhuya, learned counsel for the
July 7.
appellant and Mr. So learned counsel for the respondent. LCR has already been received. The matter is ready for hearing. The SSL is the matter for hearing immediately after reopening of the petition.
Lordship.
Item number is 17.
My lord, in this case, my lord, the respondents have entered appearance, my lord. The respondent 1 entered appearance on 16/12/24 and respondent 2 entered appearance on 9/4/25. So case is ready for hearing, my lord. And the matter was admitted on 21st October 2024.
Heard Mr. Khan, learned counsel for the appellant and Mr. D.K. Nath.
I'm for experiment 2.
Learned senior government advocate for the.
He is a private party.
Private party. Okay. Mr. Nath for respondent number 2. And Mr. Upadhyay for
1.
respondent number 1. It is submitted at the bar that LCR has been received.
LCR has been received.
That service completed and LCR has been received and the matter is ready for hearing. Accordingly, it is provided that SSL is the matter for hearing in usual course.
In the month of August, my lord.
August. Okay, take a date from him.
Item 18.
Lordship, I beg sorry, Lordship, because this matter that I have mentioned by order, this matter has come. But today, Lordship, I am sorry, but I have some difficulty, Lordship. I have taken consent of other side
Okay.
immediately after
As
petition.
agreed by learned advocates of both the parties, SSL is the matter immediately after reopening of the petition.
Yes, Lordship, in the admission column, Lordship, not in orders, it should be in admission hearing, Lordship, because record has also come and they also appeared, Lordship.
Mr. No, it has already been ordered that the matter should come for hearing.
Yes.
In due course.
Yes.
Okay, this is a lesser matter for hearing, due course.
Yes.
19.
Then I press for the applicant on call is the matter after all. After vacation.
Item 20.
May it please the court. Yeah, Lordship, IA number 3351 is for condonation of delay in filing the substitution application, Lordship. Here, during pendency of the appeal, the respondent number 1 died. Thereafter, the matter is also amicably resolved by both the parties by signing a memorandum of understanding. So now are all the parties as agreeable to dispose of this proceeding as well as the suit. So delay may be condoned, Lordship, and the appeal may be allowed and remand send back the matter before the lower court. They will file a joint compromise petition.
Matter may be remanded.
So remember that order in the appeal, that order
Yes.
has to be set aside, Lordship.
Yes.
Yes, my lord. I am appearing for the respondent number 1111213, substitute respondent number 1. So I have no any objection if the substitution is allowed and the appeal is finally disposed of. Since because the parties have already entered into an amicable settlement by way of signing of an MOU. So they want to resolve their dispute. So in that view of the matter, your honor, matter may be remanded back before the trial court by allowing the appeal. So that party will get the opportunity to settle their dispute.
Okay.
Yeah, first IA has to be disposed of, Lordship. 3 IA.
Heard Mr. Deca, learned counsel for the applicant. and also heard Mr.
PM Deca. PM Deca.
PM Deca, learned counsel for the respondent number
1, 1, 1, 1, 2, and 1, 3.
1, 1, 1, 2, and 1, 3. And Mr. Hendrik for respondent number 5 and Madam Burma. Respondent number 6 and 7 and okay. This application under section 5 of the limitation act is prepared by the applicant for condonation of delay of 125 days in preparing connected application for substitution of legal heirs of the deceased respondent number 1 by setting aside the abatement. Why there was delay of 125 days?
Delay because Lordship, the appellant number 1 is the mother and 2, 3 are son and daughter. They residing in Bangalore. So immediately after the death of her husband, she was at Bangalore. So after that, in October, when they come to Lakhimpur, the plaintiff's legal heir of the plaintiff contacted her and that they amicably settled the dispute. So after that, when they consult the lower court advocate, they advise for filing this application. Paragraph, Lordship. Six, Lordship.
Mr. Decker submits that the ground of delay in filing the petition, filing the application has been explained in paragraph number 6.
6 to 8, Lordship.
6 to 8 of the application. And that the delay is not intentional, rather the same is circumstantial, and therefore Mr. Decker consented to allow this application. The learned counsel for the respondents submits that they have no objection in the event of allowing this interlocutory application. Para taking note of the submission of learned counsel for both the parties, I have carefully gone to the application and also the grounds mentioned in paragraph number 6, 7, and 8, and I find that the delay is sufficiently explained, and accordingly, this interlocutory application allowed delay of 125 days in preferring the connected application for substitution of legal heirs of the deceased respondent number 1 and for setting aside the abatement instance allowed. And this
other two miscases, one for substitution and another for setting aside abatement.
Beleg order.
335, please.
Mr. Decker.
Yes, please.
As the substitution was allowed, you have to file amended obstacle in the appeal.
That is the Lordship. But already matter has been settled. Long
All right,
Yes.
can you next that this before vacation you can file amended cost statement?
Yes. No issue.
On that day we will pass the order.
Lordship. But these two miscases has to be disturbed.
Yes, or 3.
3352 and 3353.
No. All the miscases are disposed of.
Yes.
In view of the order passed in the I number 3351, 3351, 3352, and 3353. Mr. Decker, learned counsel for the appellant, shall file amended prospectus. Recessal is the matter on Wednesday?
Wednesday. We'll try to file tomorrow.
Tomorrow?
Tomorrow we'll file, then it will be common Wednesday.
Tomorrow is holiday, or tomorrow is a rest.
Office is open, Lord.
25th. Okay.
Obliged.
You take back this
Compromise it, Lord.
Item 23.
Lord.
May it please your lordship, the service upon the respondent is still awaited. Your lordship, I may be allowed to take fresh steps through justice services.
Office note dated 17/6/2025 indicates that. Pardon me, your good name?
M. Begum, on
Learned
behalf of I.S. Majumdar.
applicant appearing on behalf of Mr.
I.S. Majumdar.
I.S. Majumdar. Office note dated 17/6/2025 indicates that service report in respect of the sole respondent has not yet arrived. The learned counsel for the applicant submits that she may be permitted to take fresh step and also to effect service upon the respondent by the same pair is allowed. After effecting service upon the respondent, the learned counsel for the applicant shall file one affidavit before this court.
25.
Is the matter after 4 weeks?
May I please also? Also, the IA is for condonation of 390 days delay in preparing the connected LA appeal lawsuit.
May I please? Lordship?
Yes.
I'm for the opposite party number 1 lawsuit. We have filed the objection, opposition, affidavit in opposition. But I was a bit late to see the thing that it's not being tagged with our reports.
You could have mentioned the matter in
Yeah,
the
that's
morning.
why I
Then we could have called it now. It's
yes, yes. So it may be fixed on Monday, Lordship. Or I have got ready the slip as well, but it's bit less.
hardness are Devi learned counsel for the applicant and Mr. Medhi for the respondent number 1.
Yes, Lordship.
And Madam Borman for respondent number 2. Mr. Medhi submits that he has filed objection in this petition application, but the same has not been tagged with the record. Accordingly, it is provided that the SSL is the matter on Thursday. Thursday. Enclosing the objection filed by learned counsel for the respondent number 1.
1 Lordship.
26.
Okay.
Item 26.
Obliged.
Ma'am, please, Lordship. In this case, Lordship, I file an IA for releasing of 50% of awarded amount. That is 8,33,400. For releasing of the particular amount, 50% of the awarded amount.
Okay. Any objection?
Lordship, I have not filed an objection, but basically we have filed the appeal on the ground of fraud, Lordship.
On the ground of?
Fraud. And tribunal has awarded 1 lakh for loss of consortium and 1 lakh for loss of care and guidance, which should be 70,000 as per pertinent schedule, Lordship. So at this stage, Lordship, I allow 3,50,000 that may be released on bond, Lordship. That is my submission.
In this,
let it be 50% or
50%, Lordship, that is.
Subject to bond, Lordship, that may.
Yes, they will execute.
Will execute a bond, Lordship. 50%.
Mr. Sarma learned counsel for the applicant and Mr. Sarma for the respondent. This interlocutory application is prepared by the applicant for releasing 50% of the awarded amount, which is being deposited before the registry of this court by the appellant. Taking note of the submission of learned counsel for both the parties, this interlocutory application stands allowed. The applicants are allowed to withdraw the 50% of the deposited amount before the registry of this court, subject to executing a bond of equal amount.
Obliged.
27.
May I please, your Lordship? Lordship, I am the petitioner's claimant in this IA.
Lordship, in this IA, a delay of 13 days.
30 days,
13 days.
13.
13.
Let notice go at this instance.
Lordship.
It is for enhancement.
Yes, Lordship.
For its
Lordship.
28.
May it please your lordship. Lordship, there is a delay in filing the appeal, my lord. Notice may be issued. Delay of 184 days.
184 days. Okay.
29.
My lord, here, my lord, lordship, delay is there. Delay is of 135 days. Notice may be issued.
130?
5 days.
5 days. Okay.
30.
May please lordship. This is the decision delay continuation.
41 days.
41 days lordship.
Okay. Okay.
Oblige.
31.
Here, my lord, there is a delay, my lord.
Or
Delay of, my lord, 10 days, my lord.
10 days. Okay.
32.
61 days of the delay, lord. 61 days.
61 days. Okay.
33.
Oblige.
My lord, here is delay of 131 days.
131 days. Okay.
Much obliged.
34.
Wait, please, Lordship. Lordship, in this matter, I'm being led by my senior, Mr. Bhaskadev Kaur.
Mr.
Bhaskadev Kaur, my lord.
Ah.
My lord, due to some difficulty, I have to leave today, my lord. May I pray after vacations at 8?
The learned counsel for the appellant with consent from the other side, press for listing the matter immediately after reopening of the vacation fair alone.
May I pray for a fixed date, my lords? May I pray for a date?
5th August.
5th August.
I know
Right.
53. I know 41.
May I pray your lordship?
My lord, the issue is very small, my lord. What happened, my lord, the petitioner is a plaintiff, my lord. He filed a suit among various other reliefs, my lord, mainly declaratory reliefs, my lord. He alleged that, my lord, the suit part, that is the approach road, which he has been using since 1973, my lord. The defendant has made various enforcements, my lord. So accordingly, my lord, the suit was filed to remove those encroachment and for a declaratory decree, my lord, that they are not entitled to encroach upon the suit part. So, my lord, during trial, my lord, what happened, my lord, initially we filed an application in 29/4/17, page 42, my lord, for local inspection, local inspection by an advocate commissioner, my lord. And that was.
No, Mr. Security.
Yes,
You tell me, is there any provision for cancellation of the commissioner's report?
My lord, what we have, yes, my lord, because I'm coming to that, my lord, because the original application that we had filed, my lord, in 17, there was a direction passed by the learned trial court, my lord, specific direction, because the whole allegation is regarding encroachment. So it was specifically directed by the court that the commission will find out the specific, will measure the suit part along with the defendant's plots of land, and the encroachment will be, my lord, the facts regarding encroachment will be found out, my lord. That was the specific direction. So in the initial report, that was not there. So we filed objection and our objection was allowed. And then, my lord, the second commission report was, my lord, appointed. So second advocate commissioner was appointed. So now second advocate commissioner, my lord, he also, my lord, made some measurements, but not according to the directions passed by the learned trial court. So that is why, my lord, we filed an application on 15/5/25. And we prayed for rejection of our commission report and for a fresh commission, perhaps, my lord. So that was not allowed, my lord. That petition was rejected, and now, my lord, the matter has been fixed for final argument. So here in this case, my lord, there is no question of any stay or something, my lord. So this is fixed on for final argument. So at this stage, my lord, we pray, my lord, my lord will examine the matter, my lord. If the commission report is not according to the direction passed by the earlier court, my lord, then obviously, my lord, the second commission may be again, my lord, call for, my lord, commission report may be called for. Because the whole idea of Order 26, Rule 9, my lord, is to elucidate the facts.
No, that's all right, but merely because the commissioner report is not in you, not favoring you, you cannot go for.
No, I'm not into that, my lord. Kindly
go
come
for
to, my lord.
ventilation of the same.
No, I'm not into that, my lord. Kindly come to page 62, my lord. Page 62. That is the earlier direction, my lord. By this order, my lord, the predecessor of the learned trial court, my lord, relevant portion, my lord, page 64, down below, my lord. May I just read, my lord. 64, my lord. The object of local investigation is not so much to collect evidence which can be taken in court, but to obtain evidence which from the very peculiar nature can only be had at the spot. After perusal of the petition, it appears to this court that the instant petition for further commission was filed by the plaintiff, as there is no description of land available to the commissioner during the measurement of the suit part, for which he could not determine whether any encroachment was done or not by the defendants. Though the defendant number 2 raised objection against the petition, but for proper adjudication of the matter and land in dispute, these courts deem it fit to allow the prayer of the plaintiff, as the same will help the court to arrive at a just and proper decision of the suit. It is understood from the perusal of the case record that in absence of proper description of the defendant's land, it shall be difficult to ascertain as to how much land each of the defendants occupies. Again, for proper adjudication, the land of the plaintiff is also to be measured as per his land document. Hence, the concerned parties shall have to produce their land documents during the commission. Therefore, this court hereby appoints Mr. So-and-so, Advocate Commissioner, for physical verification of the suit part and the land of the defendant as well as the plaintiff as per their land documents. He may obtain help from Circle Officer, East Revenue Circle, so-and-so, concerned lot Monroe. So, my lord, this is the direction. So, this was the direction passed by the earlier trial court, and that was not followed by the commission report, my lord, in submitting the report. That is my simple case, my lord. Well, for
Okay, then we'll direct the learned trial court.
Yes, my lord.
Before proceeding to hear the argument, again he will examine the matter, whether the commission report was in compliance of the order dated 11/4/2020.
No, my lord. Regarding that, we filed a petition. That petition was at page 96. So in that petition, we have everything. We have stated everything, my lord. Why this commission report is not going to be not going to help us, my lord. That is why that petition is disposed of by the impugn order. Impugn order, my lord, at page 99. So that is already been disposed of, rejecting our prayer, my lord. So that is why we are before a lawsuit. So since the matter is for final argument, my lord, no prejudice will cause to anybody because everybody is having their own position, my lord. I'm just here, my lord, just to, my lord will examine the matter, whether or not that commission report can be acceptable, can be accepted, my lord.
No, unless the entire matter is not available before the court, can this court examine the issue?
No, I'm against the order rejecting the petition, my lord. Because we have prayed for rejection of the commission report and maybe for commissioning another report.
We will direct the trial court
My lord.
to again examine the matter. We will set aside the impugn order.
All right.
Whether the commission
Yes, ma'am.
has examined the matter in terms of the order.
Earlier direction.
Earlier direction.
Yes, ma'am. That can be done. Yes. Well, may I also show one provision, my lord, is order 26 rule 10(3), my lord. It says, may I read, my lord?
Order 26.
Order 26 rule 10 sub rule 3.
Order 26. Yes.
Yes, the commissioner may be
Sub-rule,
examined.
Order
Yes.
26 sub-rule.
10(3), my lord.
Yes.
Where the court is
Commissioner
for
may examine.
in person.
Yes.
Where the court is for any reason dissatisfied with the proceedings of the commissioner, it may direct such further inquiry to be made as it shall think fit. So further inquiry can be directed. Because, my
No.
lord,
This court will not direct the trial court this court will not direct to conduct fresh commission.
my lord,
But the court will consider, trial court. If the commission report is not in compliance of the earlier order, then the court may consider this provision.
my lord, all right. That will do, man.
But why the trial court has dismissed your petition?
My lord, because, my lord,
Where is the
kindly see, my lord, the court have, my lord, of the view that since the matter is pending since 2014, that is the anxiety of the learned trial court, perhaps, my lord. Kindly see
where
page
is
103, my lord, page 103.
103?
Yes, last page. So that was perhaps the consideration, my lord. May I read, my lord? Additionally, it is to be noted herein that the direction for commission was passed by the learned Munship number 1, Dibrugarh, so Bhait, order dated 11/4/23. That is the earlier direction, Lord, that I am talking about, my lord. And the same time and the time taken for conducting the commission and submitting report is more than 1 year, and again 1 year elapsed in the pretext of hearing on the commission's report. Furthermore, the matter is of 2014 pending since more than 10 long years for disposal. If again the matter is sent back for fresh commission and submission of report accordingly, the same would, in considered opinion of this court, be a wastage of time of this court as well as the parties. So this is the
No,
consideration.
that is the additionally. It means
Additionally.
some other grounds are also
Yes,
there.
according to the learned trial court, my lord, the commissioner has, my lord, submitted its report, my lord, according to the direction passed by the court. But my anxiety, my lord, the way if you want to, my lord, find out the enforcement, the length and breadth, these things has to be taken into consideration of the defendant's plot of land. There is a suit part, my lord. In eastern side, there is defendants. In western side, there are defendants, my lord. They have encroached upon it various multiple points. They have encroached the suit part. So if we don't, my lord, measure the defendant's plot of land by length and breadth, not relying on the revenue records, what they have done, my lord, I can come to that, my lord, if my lord allows. They have relied on the circle officer's report. Circle officer says that this is the position to 1 katha, 2 katha.
So when the next date is fixed?
My lord, today I am told, today the matter was fixed. We file an application. Then it's again fixed on 4th of July. We file an adjournment petition, my lord. So till that time, my lord may, after vacation, my lord, examine the matter. Till that time, the proceeding may be stayed, my lord.
No, but the matter is very old pending.
But that's true, my lord, but without elucidating the facts, my lord.
No, that is also one of the cause of concern.
Pendency is all right, my lord, but still, my lord, if we cannot elucidate the facts, then what is the point of, my lord, going for an argument, my lord? Because we have alleged enforcement, my lord, that has to be found out, my lord, found out. Otherwise, my lord, this is
First, let it be fixed on a Thursday.
Thursday.
I will go through the record again.
Well,
On that day, if we think that we will not be able to dispose of the matter,
well,
at motion is itself, then we will consider your interim care. Thursday. Any inconvenience? No.
26.
Heard Mr. Chakraborty, learned counsel for the petition. This is the matter of Thursday for further consideration.
Always.
Step numbers 35.
Please, my lord. My lord, I am appearing on behalf of Mr. S. Samaria, my lord. In this matter, on last occasion, we have given a direction to take.
Yes, all right. In the morning, you mentioned the matter without taking his consent.
I told him, lordship, we are trying to contact him, lordship, but in telephone directory, his landline number is there.
You have any objection?
But fix it that.
Thing is that, lordship, there is a direction for implementation.
Implementation. Even not a substitution petition.
Substitution.
Already respondent has
Expired, lordship.
expired.
And the petitioner is the corporation, lordship. We have collected the name just few days ago, so.
They will file substitution within before
You
vacation.
have filed a substitution petition.
We'll file, lordship.
Not
No.
file.
Not file. Just few days back, we get the name of the legal here.
But this order is updated 28/8/2024.
Around 1 year.
1 year.
Lordship, thing is that the legal areas not stay in Assam, lordship. They
Okay. Heard Mr.
MM Zaman, lord.
M.M. Jaman, learned counsel for the petitioner, and Mr. Pathak for the respondent. Mr. Zaman submits that conducting counsel, Mr. Sumuria, is suffering from illness.
Yes, lordship.
He is suffering from illness, and as such, he applies for listening the matter immediately after reopening of the vacation. Fair accordingly allowed to list the matter of the vacation. Interim order passed earlier.
Continue.
Shall continue.
36.
Yeah, please, Your Lordship. Lordship, we have filed our wakalatnama and we will file objection, Lordship.
When?
Lordship, I am actually not aware about the fact, and my senior is currently out of station, Lordship.
Who is your senior?
Mr. N.K. Kolita, Lordship.
N.K. Kolita.
Yes, Lordship.
Heard Mr. L. Mohan, learned counsel for the petition. Miss
P. Boru, Lordship.
P. Baru, learned counsel appearing on behalf of Mr. N.K. Kolita. Learned conducting counsel for the respondent submits that they will be filing objection and press for granting some time. There is a law. SSL is the matter. After reopening. Immediately
Interim is
after.
there, that means contact. Interim order is there.
Interim order pass service will complete.
On